Ready? Good morning. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Code Section 2-571HC of the Open Meetings Act, OMA, I'm welcoming you to the regular scheduled meeting of the Alcoholic Beverage and Cannabis Board. This meeting is being conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2-577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central Meeting calendar. The notice includes the time, date, agenda, and call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairperson of the board. I would like to introduce you to the members of the ABC board who are also participating electronically. Please respond when I announce your names. Mr. Silas Grant.
Mr. Silas Grant, present.
Ms. Terry Janine Quinn.
Ms. Terry Janine Quinn, present.
Mr. David Meadows.
Mr. David Meadows, present.
The board has 4 members in attendance for the conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 9 cases scheduled for our calendar this morning. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case is not being heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. And I would like to apologize to the members of the public that we did not start promptly at 10:30 this morning. All right, so our first order of business today is a protest hearing status, case number 25PRO00089, super convenience license number 133315. Good morning, Mr. Oriana. Can you please elevate the rights of the parties in this case?
Good morning, Chairman. I don't see anybody available for that hearing, but I'm going to ask in the chat.
Yes, please. Super convenience store. That is, as it's my understanding, there is still a hearing.
Nothing yet, Chairman.
All right, hold on. I'm going to move on, but I need to recall this case. So let me just move on, and then I'm going to recall this case in a couple of minutes. All right, the next case in our calendar, it's case number 25PRO00085, plus liquors license number 130506. Mr. Oriana, can you please elevate the parties in this case? It's the same.
Okay. Cameron Mixon, your access has been elevated. Jennifer Driver, access elevated. And that appears to be all, Chairman.
Ms. Driver, let me ask you a question. You're from what ANC are you from, ma'am?
I am from the community of 5, actually.
Oh, you're from a group of
The
it's
group
not
of
being-
5.
Oh, you are.
There-
I
it-
apologize.
I believe our ANCs or some other are on.
No, I'm sorry. This case has been protested by a group, not by the ANC. Is that correct?
There,
Mr. Chair, there's both an ANC protestant as well.
yes.
So ANC 8A is not here.
I can't see the attendees, so I don't know.
Well, who is the reason why I'm asking, because the protest hearing for the previous case was ANC 8A, and 8A was not here for the previous case, and I also see that ANC 8A is also for this case, so that's why I'm trying to get some clarification.
Oh, I see. Yes.
All right. Okay, that's fine. All right, so let me have the parties introduce themselves for the record. Let's start with you, Mr. Mixon, by introducing and spelling your name.
Morning, Mr. Chair, members of the board. Cameron Mixon, on behalf of the applicant, CAMERON MIXON.
Good morning, Mr. Mixon. Ms. Driver, can you please spell and state your name for the record, ma'am?
Yes. Good morning, Jennifer Driver, JENNIFER DRIVER, representing the group of 5.
All right. So, all right. And Mr. Mixon was, is ANC 8A a protestant in this case?
Yes.
All right. Okay. ANC 8A is a protestant in this case. This case was scheduled for a protest hearing at 10:30. It's 10:49. ANC 8A is not here. I then will make a motion that we dismiss ANC 8A from this.
Chairman, apologies.
Yes.
I do have a call-in user. Do you want me to see if that's?
I thought the call-in user said that they were just a resident, that they weren't. I'm sorry. Who's the call-in user?
One second. Call-in user, please unmute.
I guess. I'm sorry. This is the hearing was this hearing was scheduled for 8:30. I'm sorry, for 10:30. It is 10:40, so it's not a matter of since the hearing was late. It's a matter of you need to be here for the hearing at 10:30. All right, so I'm doing this case. I'm going to call one more time. Is there anyone from ANC 8A for this case? If so.
Call-in user, state your name, please.
Who's alleged? Mr. Mute your line. Mute your line, please. Mute your line. I'm sorry. Who is this call-in user? Can you identify yourself for the record, please?
Oh, this is Ashu from Virginia Market.
All right, ma'am. This is not the case. So, Mr. Oyena, can you please drop that person from this call? All right. So I guess Virginia Market. Do we have a Virginia Market today?
Yes.
Yes. That's yeah. So you can just
Elevated Jamila White.
Miss White.
Yes, how are you all? I apologize. ABCA did not send us the link.
Did you know that you had were you aware, ma'am, that there is a hearing for another case that you were supposed to be here this morning also too, ma'am?
We did not get the notification from ABCA for the hearing. I'm actually in my email now. So the commission didn't get it, and I will follow up with Ms. Fletcher.
So the commission did not get an email for either case. Is that what you're saying, ma'am?
Yes, sir. I'm looking through my emails right now, and we did not get anything since our last mediation notice.
But at the mediation, ma'am, when you have when on the notice when this matter was protested, it specifically states when the when the roll call is scheduled for, that notice also provides you information when the protest status hearing is scheduled for, and it also provides you information for when the protest hearing is scheduled. So when you protest this matter, all the information was given to you, ma'am. But I will
Yes,
check
we
with
don't,
my
I'm
office.
saying we did not have the WebEx link for it. We did not have
Alright.
the WebEx. I can share my screen right now, Mr. Donovan, if you would like to see what was sent to us.
I will. You don't have to do that, ma'am. But
Okay.
are you able to come in camera, ma'am?
Yes. I have dogs in the background, so you will see them
Right.
running around.
That's fine. Oh, well, can you please spell and state your name for the record and your
It's Jamila White, ANC 8805 Commissioner and Chair of the ANC.
Okay. All right, fine. Okay. Mr. Mixon, are there any preliminary matters in this case? Oh. Mr. Mixon, can you hear me?
Apologies, I was on mute. None at this time, Mr. Chair.
Ms. Driver, are there any preliminary matters in this case?
No.
And Ms. White, any preliminary matters?
Yes.
You said yes. Yes, meaning what? I mean, the preliminary matters are if there are any concerns that you have. That's what I'm trying to find out.
Just trying to make sure the other commissioner is getting this link to who's the single member district. So
Oh,
apologies.
well, all right, I will. All right. All that's required for this hearing is just one representative of the ANC. We will make sure that we'll check to make sure that I don't. I know that I received an email this morning. Hold on a minute, please. This is for who is Robin McKinney?
She is a single member district and the vice chair of the commission.
All right, well, and she was emailed, okay? The information was sent to her, Robin McKinney, at 8806@anc.dc.gov. Okay, so the information that was provided to me is that information was submitted to her.
Okay. I don't have access to her email, but I
As
the chair. I was on the
But I'm just saying though, that's to at least the information that I have in front of me that who were the attendees that information was submitted to. Okay. All right. All right. So, okay. If this matter, since there are no preliminary matters, if this matter is not settled, then this matter then is scheduled for a protest hearing on November 19th at 1:30 p.m. All right, hold on 1 minute, please. So let me give you the instructions. Now that this matter has been scheduled for a protest hearing, please pay attention to the following instructions. A protest hearing is an administrative trial proceeding that is decided based on testimony and evidence. The board will not decide the case based on evidence and reasoning related to the issues at hand. In proceeding to a protest hearing, you should be very clear about what you want and the basis for your request, whether it is the approval or denial of the license or the imposition of conditions on the license. The board does not intend to hear testimony in matters that are irrelevant, immaterial, or redundant to the protest issues. The board will also not decide the case based on the popularity of the parties, on reasonable speculation, or mere opinion. This means that if you're not prepared to provide evidence and reasoning to support your position, the board may not adopt your recommended action. You should have received from the agency a letter explaining the protest process and a copy of the protest information form. If you do not have these documents, please contact the agency's legal department at the end of the hearing. You're also required to complete and submit the protest information form 7 days before the date of the hearing. This document needs to be submitted to ABCA and to the opposing parties in this matter. If we do not receive a copy of your protest information form, your case may be dismissed because you did not provide appropriate notice of the evidence and arguments you intend to present at the hearing. In deciding this case, the board will decide your case based on the testimony, evidence, and materials accepted as evidence during the hearing. This means that anything you want considered should not only be submitted with the protest information form, but also formally entered into evidence during the proceedings. This further means that the board will ignore any outside comments provided by non-parties in deciding this matter unless the person are called as witnesses or a party enters those comments into evidence during the hearing. The parties are further advised that they are limited to case presentations and cross-examination of no more than 1.5 hours and 5 witnesses. If additional time or witnesses are required, please file a motion explaining why additional time or witnesses are needed. As in this case, there's more than one party protesting group. The board therefore requests that protestants designate one individual to represent the protests, the groups protesting the application. So what this means is that both the group of 5 or more and the ANC needs to get together and decide who's going to represent the protesting at this hearing. Because there's more than one protestant, so if you need more time to present your case or if you need more witnesses, you can file a motion with the board asking for more time and the opportunity to have more witnesses. But that is something that you must affirmatively request that from the board, okay? Finally, please be advised that this hearing will be conducted virtually. Therefore, it is important to ensure your technology is working, you're familiar with how to use it, you have a reliable internet connection, and you and your witnesses are in a location suitable to participate in a formal hearing for a number of hours. We thank you greatly for your cooperation. Please remember that the parties are still able to submit a settlement agreement to avoid this hearing. Any questions?
Yes, sir. Oh,
Yes, I'm sorry. Go ahead, Ms. White. I think you raised your hand.
Yes, when does that, I don't remember the exact name, but the extension request needs to be submitted by? The ANC is hiring a lawyer to represent us.
I'm sorry. All right. Is this, let me see. This is, hold on one. All right, this is a protest for a new license, unless in this particular case, unless the applicant agrees, the board will not grant an extension. Okay, if this was a renewal, then the board, if a request was made to extend the hearing, could everyone please, yeah, can you just mute your line, please, ma'am? If this was a renewal, the board, if either party requests an extension, the board would grant it. But because this is an application for a new license, unless the applicant agrees, the board will not grant any extensions to not have the hearing on November 19th at 1:30. So you can talk to Mr. Mixon to see whether or not he will agree to an extension. And if he agrees to an extension, then the parties can mutually request an extension from the board. I'm sorry, who is Miss Walters? Miss White or Miss Driver? Who's Miss Walters?
she's part of the group of 5.
Only the only person who can speak is Mr. Mixon, Miss White, or Miss Driver. So if Miss Walters, if you have a question, you need to speak to Miss Driver, and she can ask that question. But 7 days before the date of the hearing, the PIP is due, and the copy of the document must be submitted to all the parties. So a copy of it must be submitted to Mr. Mixon, and well, I guess and Ms. White and our agency, and it must be provided 7 days prior to the hearing. I just want to also inform you, Ms. Driver, that if a settlement agreement is reached between the ANC and the applicant, then your protest will fall by operation of law, because that's how the statute states. So if a settlement agreement is reached between the ANC and the applicant, then the group of five or more falls. And just as an FYI, the board cannot force the applicant to include you in a settlement agreement. Well, we hope that if a settlement agreement is reached, that all parties are in agreement. But if the group of five or more, if they disagree with the settlement agreement, if a settlement agreement is reached between the ANC and the applicant, there's really nothing the board can do but to dismiss your protest. Okay?
Thank you. I just have one question. I'm gonna
Yes, ma'am. Yeah, go ahead.
just wanna acknowledge the one in the chat. Is the applicant required to submit evidence that they intend to present in advance as well? I believe
All parties must submit. The PIP is required 7 days before the hearing, and Mr. Mixon needs to send a copy of the PIP to you and to the ANC. And
Thank
it
you.
must be done 7 days. If it's not done, then a motion can be filed, and the board can determine that if reasonable cause is that provided why the PIP is submitted late, the board could prevent that side from relying on documents that have not been disclosed 7 days in advance. Any other questions?
That's all I have. Thank you.
Sure. Good luck with your negotiation. Ms. White, I'm going to recall the first case, so why don't you stay online? So I will recall the first case that ANC 7A was not a party. So have a great day. Thank you very much. Good luck with your negotiation. Okay.
Thank you. I'll reach out to Mr. Mixon separately.
All right. Thank you. All right, so I'm going to recall case number 25 PRO 00089, super convenience, license number 133315. Ms. Oriana, can you one more time is to see if there's anyone from super convenience store available for this case?
And just to confirm, we keep Jamila White for this hearing?
Yeah, she's from ANC 8A.
I don't see anyone, but I'll put something in the chat.
Yeah, please do. All right, who is Andrea Davis? Is Andrea Davis who's Andrea Davis?
She's a single member district commissioner for where the convenience store is located.
Okay.
I'm Commissioner Davis.
Okay.
I am here.
Can you state and spell your name for the record, ma'am?
Andrea Davis, Andrea Davis, Davis.
Ms. Davis, did you get notice about this hearing this morning, ma'am?
I did not see the notice.
Okay. Ms. White, can you please spell and state your name for the record, please?
Jamila White, JAM as in Mary, ILAWHITE, chair of 8A.
And I see there is no one here from Super G Convenience. This is application for new license. And so because it's mandatory for the applicant to be at the protest hearing status, and since the person is not here, I'm going to make a motion that their application be dismissed. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Anderson, I agree the matter passed 4-0. What this means is that the ABC board will be issuing this order dismissing the application. The applicant will have 10 days to provide reasonable notice to the board. Why is it that they failed to appear today at the hearing? If reasonable notice is not provided, if the reasonable cause is not provided, then they would have to start back over again. And if they refile, you can just ask the board to reinstate your protest. So you don't have to protest again. But if they refile, you just ask the board Senate to say that we're still protesting the application. Okay, ma'am? All right. Thank you very much. Have a great day.
Thank you all.
The next case in our calendar is case number 25 PRO 00080, SUST, S-O-S-T, license number 126215. Mr. Oriana, can you please elevate the representative for the establishment and also the protestant?
I believe CM Abibi is for this hearing, and that appears to be all chairman.
CM Abibi, can you spell and state your name for the record?
Same Abibi, SIEM ABEBE.
And what's your relationship to the establishment, please?
Owner of the establishment.
I see that there is no representative from the ANC here. All right. So since there's this matter was scheduled for a protest hearing at 10:30, it's 11:09. Before we move, Mr. Oriana, can you please just put something in the chat to see if there's a representative from ANC 1B? I think, no, I'm sorry, this matter has been protested by the Civic Association. I don't think it's been represented. I don't think it's been protested by ANC 1B. I think it's by, let me ask you, yeah, let me see.
I asked in the chat, Chairman.
Thank you. Yeah, this matter has been represented, protested by the ANC and by ANC 1B and also by the Civic Association. Well, we haven't heard, and so therefore I'm going to make a motion to, this is for SOST. That's the case that we're talking about. All right. As I stated before, this matter was scheduled for a protest hearing status at 10:30. It's 11:11. There's no one from ANC 1B, and there is no one from the Civic Association that's protesting this hearing. And so therefore, I'm going to make a motion that we're going to dismiss the ANC and the Civic Association. Is there a second?
Ms. Quinn, a second.
Ms. Quinn, a second. The motion will have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Anderson, the matter passes 4-0. What this means, Mr. Abibi, is that the board will be issuing an order dismissing the protest. The ANC and the Civic Association will be provided notice. They would have to respond within 10 days to inform us why is it that they failed to appear today. If they fail to respond, or if the board determines that it was unreasonable for them not to have been here today, the board will then instruct the agency to move forward with your substantial change application, sir. Okay?
Thank you very much.
Have a great day. Thank you. Bye-bye. The next case on our calendar is case number 25 CMP 00065 501 Wine and Spirits, license number 120541. This hearing is canceled due to submission of an offer in compromise for the board's review and consideration. The next case on our calendar is case number 25 CC 00009 Chesapeake Big Market, license number 117463. Mr. Ryan, can you please elevate the government and the licensee in this case, please?
Sure thing. Christopher Southcott, access elevated, and that appears to be all, Chairman.
Thank you.
Good morning.
Good morning, sir. Can you please identify yourself for the record?
Good morning. My name is Chris Southcott. First name CHRIS, last name SOUTHCOTT, from DC's Office of the Attorney General, representing the district.
Good morning, sir. For show cause hearings, for show cause hearing status, for licensees, there's no requirement for the licensee to be here. This matter then is scheduled for a show cause hearing on December 3rd at 10:30 a.m. Just want to advise the parties that 7 days before the scheduled hearing, the parties are required to disclose documents and witnesses that they will rely upon during the hearing. Failure by either side to disclose documents and witnesses 7 days prior to the hearing, unless reasonable cause is provided, the board is empowered to prevent that side from moving forward. Any questions?
No questions.
Okay. Thank you, Mr. Shaw. All right. The next case on our calendar is case number 25 CC 00011, Virginia Market, license number 119980. Mr. Oriana, can you please elevate the licensee in this case, please?
I believe the call-in user is Ashu Bala.
Yes.
Access elevated. That is all, Chairman.
Thank you. Mr. Southcott, can you please identify yourself for the record?
Good morning.
Hi, this is Ashu Bala.
Spell your name, please, ma'am, and your relationship to this establishment.
ASHOO. Last name is Bala, B as in boy, HALLA. I'm the owner of Virginia Market LLC.
Good morning. Mr. Southcott.
Good morning. Chris Southcott. First name CHRIS, last name SEUTHCOTT, from DC's Office of the Attorney General.
Good morning, sir. Are there any preliminary matters in this case?
So the parties had been discussing an OIC. Last I spoke with Ms. Bala yesterday, she said that she would was contemplating accepting that. Ms. Bala, are you accepting the OIC that has been offered?
I had offered, yes, that we are ready to pay the fine. Please, if you can not suspend the license, that I would really not want to close the store, as it is my sales are.
Hold on, ma'am. We can't. You'd have to have the conversation offline with the Office of the Attorney General. So, from what I'm being told, this this matter then is not. All right. So this matter then is scheduled for a show cause hearing on December 3rd at 10:30 a.m. Ma'am, you can have a conversation offline with the government to see if you can negotiate the terms, ma'am. Okay. So this matter is scheduled for a show cause hearing on December 3rd at 10:30. Just want to remind the parties that 7 days before the hearing, the parties are required to disclose the documents and witnesses that they will rely upon at the hearing. Failure by either side to disclose documents and witnesses 7 days before the hearing, the board is empowered to prevent that side from moving forward. Okay. So you can have the conversation with the government offline to see if you can come up with some type of agreement. Okay.
Okay. Okay.
All right. Fine. All right. Hold on let me see. Hold on, don't leave, Mr. Saska. All right, so the next case on our calendar, it's case number 25 CMP 00063. Muchas gracias, license number 115707. This case has been canceled based on the submission of an offer in compromise to the board for its approval. The next case on our calendar is case number 25 CMP 00036, the Mayflower Club Zebby's Garden, license number 116450. This hearing has been rescheduled to November 5th, 2025 at 10:30 a.m. The next case on our calendar was supposed to be a show cause hearing at case number 25 CMP 00043. Mr. Saska, has this case has an offer of compromise been provided to the board?
So an offer of compromise has not been provided to the board. We did reach an agreement yesterday, and I sent over an OIC to the establishment for signature. I haven't received a signed copy of the OIC back, though.
All right, so are you saying then that because this case was supposed to be a show cause hearing, so it's your representation that you believe that this case is going to be settled, will be settled?
I believe it will be. I'm just waiting on a signature.
So what I'll do then for case number 25 CMPs 00043 soundbar, we will reschedule this case. We'll postpone this case. Will be scheduled for a hearing on. Let me hold on 1 minute, please. This matter then will be scheduled for hearing on November 5th at 10:30. So I'm hoping that we're hoping that the offer and compromise will be provided. So I'm just gonna move this case to November 5th, which is next week. No, November 5th at 10:30. Okay.
Okay.
All right. Thank you. Have a great day. All right. All right, so we have concluded our calendar for the morning. So I'm going to do our agenda for the morning. So the first agenda item that we will do this morning is our legal agenda alcohol. And the first matter on the legal agenda alcohol is a review of a settlement agreement dated October 8th, 2025 by and between Advisory Neighborhood Commission 2B and Astro Zombie, license number 133948. I make a motion that the settlement agreement is approved. Is there a second?
Ms. Quinn, I second.
Ms. Quinn has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passes 4-0. The next case on the calendar is review. I'm sorry, on the agenda is review of a settlement agreement dated October 15th, 2025 between Advisory Neighborhood Commission 1A and Bujo's Restaurant, license number 133735. I make a motion that the settlement agreement be approved. Is there a second?
Mr. Meadows, I second the motion.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. Number 3, review of a settlement agreement dated October 9th, 2025 between Advisory Neighborhood Commission 1B and Frank's Wall Years, license number 133405. I make a motion that the agreement be approved. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Anderson, I agree. The matter passed 4-0. Number 4, review of settlement agreement dated October 19th, 2025 between Advisory Neighborhood Commission 3E and Max Tavern Tenley, license number 126121. I make a motion that the agreement be approved. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
and Mr. Anderson, I agree. The matter passed 4-0. Number 5, review of an offer in compromise. This is for case number 25 CMP 00065. This is 501 Wine and Spirits license number 120541. And the offer in compromise is as follows. Charge 1, operated outside of board approved hours, statutory authority, DC Code Section 25-762A B13, a warning will be issued for charge 1. Charge 2, no ABC manager and failed to secure alcohol beverage, statutory authority, DC Code Section 25-701 and 25-823A 1 and 3. There is a fine of $250 payable within 30 days, or the license shall be suspended indefinitely until the fine has been paid. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Mr. Meadows, I second.
Mr. Meadows will second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
and Mr. Anderson, I agree. The matter passed 4-0. We now move to our legal agenda alcohol addendum. Number 1 in this addendum, review of a settlement agreement dated October 13th, 2025 by and between Advisory Neighborhood Commission, 2B, and Across the Pond Restaurant and Pub, license number 106099. I make a motion that the settlement agreement be approved. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
and Mr. Anderson, I agree. The matter passed 4-0. Number 2, review of a settlement agreement dated October 17th, 2025 by and between Advisory Neighborhood Commission 2E, the Citizens Association of Georgetown, and Andy's Pizza, Wisconsin Avenue, license number 133330. I make a motion that the that the agreement be approved. Is there a second?
Mr. Meadows, I second the motion.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Anderson, I agree. The matter passed 4-0. And the next matter on this agenda, it's an offer in compromise. This is for case number 25 CMP 00063, Muchas Gracias, license number 115707. And the offer in compromise is as follows. Charge 1, operate a sidewalk cafe without a board endorsement, statutory authority, DC Code Section 25-762B2. A warning will be issued. And so therefore, I make a motion that this offer in compromise be accepted. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
and Mr. Anderson, I agree. The matter passed 4-0. We now move to our legal agenda, medical cannabis. Number 1 on this agenda. Yeah. Number one on this agenda, it's case number 25 ULC 00042. It's Temple of the Golden Teacher. And the offer and compromise is as follows. Property owner affirms that it has received affirmative confirmation from respondent that acknowledges the termination of its lease and intention to vacate the premises as evidenced by Exhibit A. Number two, property owner acknowledges that it is responsible for returning any property owned by respondent that remains in the premise and over which respondent has a legal right to return. Number three, property owner agrees to not lease the premises to respondent or its successor companies or any unlicensed cannabis establishment or establishment that distributes Schedule I drugs at any time in the future. Number four, property owner agrees to notify ABCA when it has leased the premises to a new tenant to provide the identity of the new tenant, including the business name and owner, and permit ABCA to perform an inspection before the new tenant takes possession of the premises and at any time thereafter. Number five, property owner agrees that if a future tenant which has not filed and accepted and pending application with the ABC board knowingly engages or attempts to engage in the purchase, sale, exchange, delivery, or another form of commercial transaction involving cannabis, or if a future tenant distributes, attempts to distribute, or makes available for sale Schedule I substances, it shall be a subsequent violation of DC Code Section 7-1671.08F and ground for the board to issue a subsequent notice of summary closure and issue property owner a fine of up to $10,000 under DC Code Section 7-1675.01B. Property owner agrees to waive the notice requirements set forth in DC Code Section 7-1675.01A. And number 6, the current summary closure shall remain in effect until ABCA makes the keys to the premises available to property owner for pickup at its offices or at another mutually agreed upon time and location. I therefore make a motion that the offer and compromise be accepted. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passes 4-0. Number 2. Review of motion to amend board order number 25-929. This is case number 25CC 00021. ABCO 127461. I make a motion that we approve the order in part and deny in part. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. Number 2, review of the District of Columbia's response to respondents' motion to amend board order number 2025-929 Chocolate City Wellness. This is in case number 25CC 00021, license number 127461. This is an FYI for the board. We move to the legal agenda medical cannabis addendum. And on the addendum, number 1, review of a settlement agreement. This is for Velvet's license number 13078. I make a motion that we approve this agreement. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. Number 2, this is an offer in compromise for case number 25 ULC 00064. It's Heady Club DC. And the first offer in compromise, this one is regarding the respondent. Number 1, respondent agrees to not sell cannabis and cannabis products, including all cannabinoids, hemp, CBD, tetrahydrocannabinolic acid, THC-A, and THC, kratom, and any Schedule I substance, including psychedelic mushrooms, at the premises, online, or at any other location, District of Columbia, without a medical cannabis retail license. Number 2, respondent affirms that it has permanently vacated and terminated its lease of the premises as evidenced by Exhibit A. Number 3, respondent agrees that if it violates DC Code Section 7-1671.08F at any time in the future, it shall be a subsequent violation under DC Code Section 7-1671.08F2, and grounds for the board to issue a fine in the amount of $20,000 under DC Code Section 7-1671.08F2A. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Ms. Quinn, I second.
Ms. Quinn has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. Number 2, review of offer in compromise. This is for the landlord. This is for case number 25 ULC 00064, Headley Club DC. The offer in compromise as follows. Number 1, property owner affirms that it has received affirmative confirmation that Kahan, K-H-A-N-H, Nguyen, N-G-U-Y-E-N, owner of Headley Club DC, acknowledges the termination of its lease and intention to vacate the premises as evidenced by Exhibit A. Property owner acknowledges that it is responsible for returning any property owned by Headley Club DC that remains in the premises and over which Headley Club DC has a legal right of return. Number 3, property owner agrees to not lease the premise to Headley Club DC or its successor companies or any unlicensed cannabis establishment at any time in the future. Number 4, property owner agrees to notify ABCA when it has leased the premises to a new tenant to provide the identity of the new tenant, including the business name and owner, and permit ABCA to perform an inspection before the new tenant takes possession of the premises at any time thereafter. Number 5, property owner agrees that if a future tenant at the premises which has not filed and accepted an pending application with the ABC board knowingly engage or attempts to engage in a purchase, sale, exchange, delivery, or another form of commercial transaction involving cannabis, it shall be a subsequent violation of DC Code Section 7-1671.08F and grounds for the board to issue a subsequent notice of summary closure and issue landlord a fine up to $10,000 under DC Code Section 7-1675.01B, and a property owner agrees to waive the notice requirements set forth in DC Code Section 7-1675.01A. 6, the summary closure shall remain in effect until ABCA makes the keys to the premises available to property owner for pickup at its office or another mutually agreed upon time and location. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Mr. Meadows, I second the motion.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter pass 4-0. Excuse me. Let's now move to our alcohol licensing agenda. And on this agenda, there are two applications. I will review both applications and then I'll make a motion. And I will ask the ABC, I'll make a motion asking ABC board members to vote to approve the recommendation as put forth by the chair. Number one, review application for safekeeping of license. This is for to be determined, formerly Jerk Pit, license number 134313. The recommendation is to approve the safekeeping request through March 31st, 2026. Number two, review application for the carryout and delivery endorsement. This is for Crush Bar, license number 127498, and this is a approval. I therefore make a motion that ABC board members vote to approve the recommendation as put forth by the chair for the alcohol licensing agenda. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn. Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. And Ms. Quinn voted to approve. I apologize for we're actually having the technical issues that we're having today is our own creation because we're all in the same location. And so we have to make sure that when we're in the same location that either our mics are off or on to do this here. And so I apologize for that. So now let's move to the supplemental licensing agenda. And on the supplemental licensing agenda, there are three applications on this agenda. I'll review all three, make some recommendations, then I'll make a motion that ABC board approves the recommendation that's put forth by the chair. Number one, review request to remove the license from safekeeping for reopening at the new location. This is for Bourbon and More, license number 122551, recommendation approval. Number two, review request to remove the license from safekeeping for reopening. This is for Hammer and Nails DuPont, license number 124770, recommendation approval. Number three, review request for an auction permit for a personal estate sale from October 31st to November 2nd. This is for Bethesda Potomac Estate Sales. The license is 25-SC-01241, recommendation approval. I therefore make a motion that ABC board members vote to approve the recommendations as put forth for the chair for the supplemental alcohol licensing agenda. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
And I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passes 4-0. We now move to our second supplemental licensing agenda. And number one, review request to extend the total occupancy load of the premises from 380 to 481. This is in Sea Los Angeles, license number 131487. I make a motion that we approve this. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. We now move to our vacate cease and desist orders agenda. The ABC board is vacating the following orders to cease and desist previously issued on October 22nd, 2025. Number 1, KW Store license number 120355. Licensee paid the third year annual payment on October 22nd. Number 2, Povet USA Inc. license number 109297. The licensee paid the third year annual payment on October 24th, 2025. I therefore make a motion that ABC board votes to vacate the cease and desist orders agenda. The licensees on this agenda. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passes 4-0. We now move to our cancellation agenda. ABC board will be canceling the following license for the reasons outlined below. Dad Strength Brewing / Atlas Brew Works, license number 091282. The licensee requested cancellation. I therefore make a motion that this license be canceled. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passes 4-0. Hold on 1 minute, please. All right, so let's move to the board's temporary license for one-day substantial change docket. There are 11 applications on this agenda. I'm going to review all 11, make some recommendations, and then I will make a motion that ABC board members vote to approve the recommendation as put forth by the chair. Number 1, a request from Sydney Yassim. This is for one-day license class F. This is for soft opening. This is October 30th and November 2nd. The license number is 134369. 85 attendees, 2 security guards. Recommendation approval. Number 2, a request from Justin Deckelbaum, Dekelbaum, for one-day license class F. This is a reception. This is November 12th. The license number is 134392. 120 attendees, 2 security guards. Recommendation approval. Number 3, a request from Nigel Okunbi, Okunbi, for one-day license class F. Musical showcase October 31st. The license number is 134390. 60 attendees, staff, security guards, and recommendation approval. Number 4 is another request from Nigel Akambu. One-day license class F is comedy, November 8th. The license number is 134389. 60 attendees, the hotel security guards. Recommendation approval. Number 5, request from Millicent Hawkins one-day license class G, 65th birthday party, November 8th. The license number is 134363. 200 attendees, 2 security guards. Recommendation approval. Number 6, a request from Michael Smith, one-day license class G, Nippon SIP, November 14th. The license number is 134364. 200 attendees, 4 security guards. Recommendation approval. Number 7, a request from Darren Hines, one-day license class G, pre-opening event. This is October 29th and October 30th. The license number is 134365. 324 attendees, staff, security guards. Recommendation approval. Number 8, a request from Navid Zahari, Zahraie, one-day license class G concert, October 31st. License number is 134375. 350 attendees, 4 security guards. Recommendation approval. Number 9, a request from Joseph Raganosi, Ragonesc, one-day license class G, happy hour and corporate networking, November 6th. The license number is 134397. 50 to 70 attendees, 2 security guards. Recommendation approval. Number 10, a request from La Oficina, one-day substantial change, live entertainment. Nature of substantial change is to change use of license off premises at Dock Masters at the Wharf. This is November 8th. The license number is 107664. Substantial change license is 25 SC-01227. Recommendation approval. And number 11, the consortium for one-day substantial change, Idle Talent Show and After Party. Nature of substantial change, seeking to extend hours of operation to 3 a.m. and offer live entertainment. This is November 1st. The license number is 130329. Substantial change license 25-SC-01237. Recommendation approval. I therefore make a motion that ABC board members vote to approve the recommendation as put forth by the chair for the temporary one-day and substantial change docket. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Anderson, I agree. The matter passed 4-0. We now move to the alcohol license administrative docket. On this docket, there are 16 applications, and without objection, I make a motion that ABC board members vote to approve the alcohol license administrative docket for October 29th. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. We now move to our medical cannabis licensing agenda. There are 2 applications on this agenda. I will review both names and then I will make recommendations, and then I will ask the ABC board to vote to approve the recommendations that's put forth by the chair. Number 1, review of standard application for a new retailer license with delivery endorsement. This is Greenway, license number 129363, recommendation placard. Number 2, review of social equity application for retail license with delivery endorsement to add educational tasting endorsement. This is for Embers, license number 126772, recommendation approval. I therefore make a motion that ABC board members vote to approve the recommendation that's put forth for the chair for the medical cannabis licensing agenda. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. We now move to our medical cannabis licensing supplemental agenda. Number 1, review of social equity application for new retail license with delivery endorsement. This is for SM Quest Industries, Inc., license number 128882. Recommendation to refer this matter back to licensing. I therefore make a motion that ABC board members vote to refer this matter back to licenses. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
and Mr. Anderson, I agree. The matter passed 4-0. We now move to our medical cannabis license administrative docket. On this docket, there are five applications, and without objection, I make a motion that ABC board members vote to approve the medical cannabis license and administrative docket for October 29th. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
and Mr. Anderson, I agree. The matter passed 4-0. We're at the end of our agenda items for the morning, and since there are no other business, the board will going to recess until our afternoon hearing. So we will be back at 1:30. Have a great morning. Thank you. We're on the record. Good afternoon, everyone, and welcome to the afternoon session of the ABC Board. My name is Donovan Anderson. I'm chairman of the board. Joining me this afternoon are four of the board members: Mr. Silas Grant, Ms. Terry Janine Quinn, Mr. David Meadows, and Mr. Ryan Jones. The board has 5 members in attendance to conduct business, and that constitutes a quorum. And so let's go to our afternoon to see what we have in the afternoon. So the first case in our afternoon, I'm going to call cases out of order. So the first case that's on the calendar for the afternoon is a summary action for case number 25 ULC 00057, Sky's the Limit, unlicensed cannabis retailer. That hearing has been canceled. The next case on our calendar is case number 25 PRO 00082, Theta Oasis, license number 129034. This hearing has been rescheduled to November 19th at 1:30 p.m. And another case that's on our calendar, case number 25 PRO 00076, Apayo, license number 94795. This hearing has been canceled due to submission of a settlement agreement for the board's review and approval. So the only case that we have on our calendar this afternoon is a protest hearing, case number 25 PRO 00078, Sliced and Brewed Restaurant, license number 115871. Good afternoon, Ms. Doriana. Can you please elevate the rights of the parties in this case?
Good afternoon. Richard Bianco, your access has been elevated. David Greer, access elevated. Frank Chauvin, access elevated. Thomas M. Abibi, access elevated. And that appears to be all, Chairman.
Thank you. Could everyone please come on camera? Mr. Chauvin, are you able to come in camera, sir? Mr. Chauvin, are you able to come in camera, sir?
I'm trying to communicate with him.
Thank you. Mr. Greer, can you mute your line, please? Mr. Greer, can you mute your line, please, sir? Thank you.
Not getting a response from Mr. Chauvin.
Mr. Abibi, can you mute your line, sir? Thank you.
Mr. Chauvin, can you hear us?
I can now, and I can't seem to come on. I have this all the time. Every time I log in on your platform, I can't show my video.
Are you joined through the web browser?
I am joining through the web browser. Yes.
It requires approval, web browser approval to grant camera access. You may have to try it on a different web browser potentially.
Okay. And this explains several instances before you, and I've been trying to get this technical problem resolved, and thank you for getting me a step closer for a resolution here. So I should try another browser then, or
Yeah, or when you're joining, there's an option to join with the WebEx app. That's the ideal way to join.
okay, I don't think I was ever informed of that. Thank you. Let me try with the web browser, or I can just continue in this fashion.
No, sir. I prefer to see you if possible.
All right.
I would suggest logging out, log back in, potentially on a different web browser, and then you should see an option to. Oh, never mind.
All right. Mr. Orina, where is the investigator? I don't see an investigator online.
Investigator Kendall Williams, access elevated.
Thank you. Mr. Chauvin, what's going on, sir?
Looks like he's trying.
All right, thanks.
He's back, Chairman. Mr. Chauvin?
Thank you. Mr. Chauvin, what's going on, sir?
He's going to log in on a mobile device.
Thank you.
I hear you.
Yeah, I can hear you, but I still can't see you, sir.
guess what?
Okay, now yes, okay, good. Good afternoon, everyone. Let me have the parties identify themselves for the record. So let's start with you, Mr. Bianco.
Good afternoon, Mr. Chair, members of the board. My name is Richard Bianco. I represent the applicant in this case, Zemin M LLC. With me from the applicant, I have my clients, and I will have them introduce themselves and spell their names for the record.
Yes,
Thomas, go ahead.
Please unmute yourself and please identify yourself for the record.
My name is Thomas M. Abebe, ABEBE. I'm the applicant's son.
My name is Martha, Martha, Thomas Zemenfas, Zemenfas.
Now, so who is the licensee, Mr. Bianco?
So the licensee is an LLC. The LLC is owned by Martha and Tamara Zemenfez. Thomas Abebe is the general manager of the establishment, and he's going to be my designated representative and witness.
All right, thank you.
Martha's just observing.
Okay, thank you. Mr. Chauvin, can you please identify yourself for the record?
My name is Frank Chauvin. I am the designated representative for the Westminster Neighborhood Association. My name is FRANK CHAUVIN for the record.
All right. Mr. Bianco, are there any preliminary matters?
There is one preliminary matter. I think, as the board is probably aware, the WNA's PIF was late filed at some point on Friday. While I note that, that's not my main issue. What my main issue is with respect to WNA's case is that no witness list was filed. So I'd just like to clarify at the outset that they won't be calling any witnesses in this matter.
Well, I mean, if there's no witness if a PIF was filed and there are no witnesses on the PIF, I mean, outside of the fact that Mr. Chauvin, I mean, the expectation that if any witness, Mr. Chauvin would be a witness, but maybe you can answer that question, sir. So let me, I guess, before we move on, Mr. Bianco. So what is your?
So the PIF says there's a witness list, but there is in fact no witness list. So my assumption is there's no witnesses. So I have no objection if there is in fact no witnesses, but if there are witnesses that were not included, then I would have an objection.
All right, so Mr. Chauvin, are there witnesses that you plan to call today?
There are, and there was a submission of 3 emails to ABCA. The first email presented my PIF along with the attached witness list. The second 2 emails were additional submittals. I wasn't aware that it wasn't received. I have a copy here as it being sent the same time the other 2 emails were sent with the content submittals.
All right, so when is it? Well, when did you send your PIF, sir?
The Friday, when as referenced by Mr. Bianco.
And who are the witnesses that are on this?
There's 2 neighbors, David Greer, and my second one, Mario Gill, neighbors.
So, Mr. Bianco.
I'm in receipt of 3 emails from Mr. Chauvin on Friday the 24th. None of them had a witness list attached. So I object to them being able to call witnesses that were not disclosed in advance of today's hearing. Friday was late to begin with, but it has, until this moment, I had no idea that there were witnesses.
So what's your objection then, sir?
Our objection is to WNA being able to call any witnesses that were not disclosed in their PIF filing.
Mr. Chauvin.
They're neighbors, and it was in my sent email. I'm pulling up my sent email. I didn't hear back from ABCA whether or not they received anything. And it was in my first email. So
let me back up. Mr. Bianco, when was the all right, so are you objecting to the late filing, or are you objecting to the what are you objecting to? The late filing or to the fact that they're tell me what specifically what you're objecting to, sir.
I'm objecting to both. I'm objecting that it was late filed and that it does not contain a witness list.
And when was it PIP due, sir?
So it was due on Wednesday, the 22nd, which is when we filed our PIF. And I'm looking at the first email sent by Mr. Chauvin on Friday, October 24th at 11:42 p.m. There are two attachments, neither of which is a witness list. There's two subsequent emails sent a few minutes later that contain some numbered exhibits, numbers 3 through 8. None of those are witness lists either. So we object on both timeliness grounds, and we object on them calling any witnesses that have never been disclosed.
So you're saying it was filed 10/24 at what time?
11, there were three emails, 11:42 p.m., 11:44 p.m., and 11:44 p.m. So there were three emails sent. None of them contained a witness list.
You say 11:42, 11:40 what?
11:42, 11:44, and 11:44.
So basically, all right. So Mr. Chauvin, you are aware that the PIP was due on 10/22, right?
Yes.
You
The
filed your.
preceding-
Go ahead, sir. Go ahead.
The preceding day, I believe,
No, sir.
2 days prior.
It was due on 10/22, which is Wednesday.
Yeah.
I'm being told they were filed late. Okay, the 24th. Okay, hold on.
Yes.
They were due Wednesday. I guess close of business, depending either. I don't know. They're due on Wednesday, the 10/22. They were filed on 10/24 at 11:42 and 11:44 p.m. So basically, you could say Saturday or anyway. But so why were they filed late, sir?
Well, the applicant had filed a motion for dismissal of our case, though we had voted upon at the Westminster Neighborhood Association with 7 days advance notice to the membership, and a contention was raised by the applicant's attorney that it was asked for a dismissal, and we didn't get a notice on the dismissal order until Wednesday, which is the day before I filed. I'm sorry, came in Wednesday, 2 days before I filed, the date on which it was due. I thought it was a done deal because I sought some legal help, and we thought we had lost the ability to proceed. But your order came back on Wednesday telling us we did not lose that order to proceed. So I had to quickly pull together the case I'd been building, and the Westminster's been building, and we therefore were late. And we were submitted late with asking with prejudice, no prejudice grounds, that a few days and the slight material that were submitted are all items that the applicant and their attorney are aware of.
But the counsel states that he did not receive that. The document was submitted late.
Yeah, the witness
but
list.
He never received a witness list. So
yes, it was omitted.
Hold on. So if no witness list was omitted, you can't call a witness today, sir. So even if the board was to vote to say, even if we were to make a decision whether or not it was reasonable for you not to have filed your PIP within the 7 days, you never provide a witness list.
Yep, I just found out it was omitted on my submission, that first email, and so therefore I will be called as the only witness and presenting testimony.
Hold on. Hold on, Mr. Chauvin. You broke up. So
I said I realize I did not submit. It was an oversight on my submittal. My two folks who are present today, ready to protest, taking time out of their afternoon as volunteers to help the association. They are sitting here on waiting to testify. But in light of the fact that I failed to attach the file with these two names, and if the board finds that I am an abuse of the protocol and that Westminster can't allow these two folks who have taken time off their day to present today, then I would like to say that I will be the only witness, and I will speak to all of the submittals and the submittals supported by the applicant, submitted by the applicant.
Mr. Bianco.
So I don't want to belabor the point. I understand it's the board's practice, even when the witness list is submitted, to allow the protestant him or herself to protest. So I'll just note the objection for the record. And our position is that the additional witnesses that have not disclosed, that I still don't know who they are, should not be permitted to testify.
All right. So, Mr. Chauvin, as you are aware, the regulation 1713.2 clearly states that you're supposed to provide the PIP 7 calendar days prior to the hearing. So you have 1713.2, 1713.11, and the regulations 1722.6 also states that the board may exclude witnesses.
Yes.
May. And but so outside of Mr. Chauvin testify, what harm is it to you, Mr. Bianco, if I was to allow these other two witnesses if the board was to allow these other two witnesses to testify?
Sure. I don't have any idea who they are, and I don't have any idea what they're going to say. And I can tell you my normal process in dealing with either neighborhood association or neighbor testimony at these hearings is to do some kind of advanced vetting. So knowing where they are and who they live, who they are and where they live is essential to that process, because if they're going to be complaining, as in this case, about the existence of an outdoor cafe, knowing where they live in proximity to it, and whether they're owners or renters and how long they've been there are all things that factor into how we present our case. We've obviously prepared our case before today, and having to adjust it on the fly based on some unexpected testimony is extremely prejudicial to us.
Mr. Chauvin?
It's the age-old approximate neighbor that has simply to testify. Some of the adverse impacts that living in this neighborhood.
Hold on, Mr. Chauvin. It's not. Their testimony is not relevant in the sense that what we're discussing is the fact that you never put him on notice prior to now that you're calling these witnesses. That's the argument I need you to make, sir. So I don't need you to talk about the substance of their testimony. It's the issue is that why should they be allowed to testify since you did not put the applicant a notice that you're having any witnesses testify today? I mean, if you're the only person, if you didn't do a PIP, and if you're the only person testifying, I think that one would reasonably expect that you would testify. So even if your name was not listed, that would be fine. I mean, that could be permissible. But the issue is that for the first time, you're listing two witnesses at this hearing, and counsel is saying that your PIP was late. It was filed late. You did not list any witnesses, and now for the first time at the hearing, you want two witnesses to testify, and so he's saying that his client is being prejudicial because he was not previously aware that you were calling witnesses. That's the issue that I need you to argue, sir.
Sure. My argument is that he won't be prejudicial, allowing the witnesses, because the board may allow for the witnesses. And we are a volunteer organization, and we, seek, due diligence with respect to this protest because we've prepared for it diligently and made some non-expert mistakes here, being that we do not do this full time and we seek to represent our neighborhood. So ask the board for the May part of allowing the witnesses to proceed as the applicant and their attorney is not being prejudiced. It's
All right, I'm going to go in executive session for, give me about 5 minutes just to briefly discuss it. Hold on. So just, hold on, please. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with DC Code Section 252-575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number, on case number 25 PRO 00078, Sliced and Brew Restaurant, pursuant to DC Official Code Section 2-575B4A of the Open Meetings Act. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, a second the motion. We'll have a roll call vote. Mr. Grant, Ms. Quinn,
Ms. Quinn, I
Grant, I
agree.
agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
and Mr. Anderson, I agree. We'll be in recess for 5 minutes. It's 2:05. It's 2:02. We'll be back on the record at 2:07. Okay. Thank you.
sorry about the confusion.
All right, we're back in the record. Where's Mr. Bianco? Is he there?
I'm here.
All right. All right, the board went into executive session. I think that Mr. Bianco had raised, at the applicant's attorney had raised an objection to having to the board we went off the record to discuss the motion that was filed by the applicant, and the PIP was filed late, and counsel also stated that these two witnesses that he was not provided prior notice that the witness would be able to testify today. So I'm going to make a motion to allow Mr. Shelvin to testify. However, the motion would be that the additional witnesses who were not disclosed timely would not be able to testify because advising the applicant at the hearing that two additional witnesses would testify. I think that's prejudicial. So the motion is to allow Mr. Chauvin to testify, but not to allow any additional witnesses to testify. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant is second the motion. We have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
I do not agree.
And Mr. Anderson, I agree. The motion passed 4-1. All right, fine. Mr. Williams, we're all in the office, and I see someone walking along, walking. So I was trying to figure out they're walking behind me, but it's you or the person was walking behind. Okay, that's fine. All right. So the motion is that the motion passes. So Mr. Chauvin, you'll be able to testify, but your witnesses will not be able to testify. So, all right. So let me ask you a question to move forward with this hearing. Mr. Chauvin, is it the WNA's position that we should not grant the substantial change, or is it that to grant the substantial change with conditions? I can't hear you, sir. I cannot hear you.
I like to respond in that we'd sort of like it both ways. We love to grant, but we want conditions to protect the moratorium. So I will say that I guess proceed and hopefully establish reasoning for conditions to be applied.
All right. So what we will do then, the board will approve the substantial change. You can then provide arguments why we should grant conditions to the license. And Mr. Bianco, then your testimony should be why there should be no conditions on a substantial change. Is that agreeable to both sides?
That's agreeable to the applicant.
Mr. Chauvin?
Agreeable. May I make a comment, however? Any way we could postpone this hearing so I can call my witnesses in a week or next week or two weeks? Would the applicant be amenable?
Mr. Bianco?
We wouldn't, only because we already have an agreement in place with the ANC. It's been approved by the board. We're ready to open, but for this protest, so it's holding us up.
So no, Mr. Chauvin, since the applicant does not agree.
May I respond to the assertion made?
What assertion, sir? I'm not gonna. What is it you want to respond to?
That the applicant is not ready to open. They haven't been open and operating for 3 years.
Mr. Chauvin, that's not your call. I mean, I can only state what the applicant states. I mean, you can just state that the applicant is not ready. The applicant state that he's ready, and you just can't make a statement that they're not ready. So, okay, so that's what so the applicant doesn't agree for that to occur. So let me ask you a question. Do we need the investigator to testify? We do? You said you do, Mr. Chauvin?
Yes.
All right, okay. All right, so I'll ask each part. So anyway, so this hearing is just gonna be limited to whether or not what conditions, if any, should be provided on the substantial change, okay? So the hearing will somewhat be truncated because we are gonna approve the substantial change, but this hearing is limited to whether or not we should add conditions to whether or not there should be any conditions on the substantial change. So what I'll ask the parties, we can have brief opening statements by the applicant, by the and then by the WNA, and then we'll have some truncated testimony by the board's agent. We'll have, after the board will ask questions of its agent, and then you, Mr. Bianco, will have some questions of the agent, then Mr. Chauvin, and then Mr. Bianco, you can put your case on, okay?
Very well.
All right, so do you wish to make a brief opening statement, sir?
I do. The licensee in this case is M&M LLC, which trades as Sliced and Brewed at 1915 9th Street Northwest. It is a very small takeout that operates on 2 floors. The first floor has counter service where patrons can order and pick up their food. There's no seating. And the second floor features a bar with 8 stools and 2 high-top tables for 2 and 2 two-person benches. All told, they have seating for about 16 patrons. The standing room and the bar dining room area on the second floor is negligible. At present, the total square footage, including the kitchen and storage area, is 1,500 square feet. The customer area is about 1,000 square feet. The official occupancy is 64, included seating and standing, but realistically, they don't have anywhere near that in terms of their ability to accommodate people. Presently, their approved operating hours are from noon until 5 a.m. every day. Their service of alcohol hours are from noon until 2 a.m. during the week and 3 a.m. on Fridays and Saturdays. They have live entertainment, and I have live entertainment in quotes here because they don't actually offer any live entertainment. They have 2 interior speakers located on the second floor, which are aimed inwards, which they use to play recorded background music. Sliced and Brewed, as the name suggests, is and has been since 2018 a late night pizza slice joint. They serve club goers from the roughly 70 nightlife venues within the relevant area. They obviously have a liquor license, which is why we're here today, but alcohol service is not a big part of their business. In the last 5 years, they've only had weekly alcohol sales of more than $500 2 to 3 times. It's just not a big part of their business model. The establishment is owned and operated by the Zemenfez family. They're a pillar of the Little Ethiopia business community, and were among the first to open the business on the 1900 block of 9th Street more than 30 years ago. It was actually back in 1991 when the 1900 block of 9th Street was not the nightlife hub and destination that it is today, but rather a blighted area of boarded up row houses. Martha and Tamru opened Metro Market, which is now Habishaw Market, at a time when the community had no grocery options. Tamru Zemenfez and his wife Martha, and now their children, are really the embodiment of an American immigrant success story. They came here from Ethiopia with nothing, and through hard work, perseverance, and grit, have built successful businesses on both the 1900 block of 9th Street and east of the river. It's also important to note that they've worked really, really hard to do this the right way. They forged relationships with the surrounding community through service, their generosity, and leadership, among other Ethiopian business owners on 9th Street. Tamru and Martha have been formally commended by Mayors Williams, Fenty, and Bowser for their contributions to the community. And in their time at 1915 9th Street, other than a warning for a secondary tier offense in 2021, they have never had an ABC violation, nor have there been noise complaints, or other disturbances at the licensed premises, as you can see from the investigative report, and as is the hallmark of some of the surrounding establishments that are maybe not so community conscious. The application before the board is for a substantial change in operation to add a 24-seat summer garden at the rear of the property. It's important to note that per DOB, the deck's already built, so it's important to note that per DOB, the deck can accommodate 48 people, but they're only seeking approval for 24. You'll hear from Thomas Abebe, Martha and Tamaru's oldest son and the manager of the operations of the establishment, is that their plan is to transition from a late night pizza slice place to more sit-down dining. They're changing their menu from pizza and stromboli to Peruvian chicken. They've changed out the kitchen equipment already and have been testing out their new menu while this application is in process. It's been well received. It seems to be successful, and they're ready to roll out their new offerings once the change is approved. The business will still be a takeout. The setup is going to remain basically the same with the addition of the deck, but with expanded on-premises dining, they're going to be seeking more of a lunch and dinner business rather than after hours. If we open as anticipated in the spring of 26, the business will be rebranded as the Terrace. That's not part of this application because, of course, we can't call an establishment a terrace if it doesn't have a terrace. So we're hoping for success here, and we'll roll out that rebranding thereafter. The Zemenfez family is committed to this new business model of lunch and dinner, as they've voluntarily restricted the hours of their operation, sales, and service, and their outdoor occupancy as part of this application. It's always their goal to work with the neighborhood, and this is no exception. Before a protest by the ANC, they reached out and negotiated a settlement agreement. And in that agreement, they've formalized their commitment. So they've put their money where their mouth is here. Even though they presently have operating hours till 5 a.m., they're voluntarily reducing those. They're no longer going to operate during those hours. They're voluntarily reducing those to 2 a.m. during the week and 3 a.m. on the weekends. Presently, they have maximum legal hours with respect to sales and service. Again, they're voluntarily reducing those hours. They're going back to 1 a.m. during the week and 2 a.m. on the weekends. They are voluntarily closing the second floor, their interior operations, at 1 a.m. during the week and 2 a.m. on the weekends, and limiting outdoor hours to midnight every night of the week. They are offering no outdoor entertainment, nor will they. And they are limiting indoor entertainment, which is not presently limited. They're limiting indoor entertainment to 1 a.m. during the week. Finally, and I think, something that was very, very important to the ANC is that they are prohibiting any amplified sound on the summer garden after 10 p.m. on weekdays. The settlement agreement with the ANC, with the aforementioned safeguards and limitations, was approved by the board back in August. Mr. Abebe will testify that he made the concessions in the settlement agreement, which are more onerous than the agreements at any of the neighboring establishments, at a time when hospitality businesses are hurting very badly and actually going in the other direction. Places are fighting very hard for more hours, having patrons in their establishments longer, being able to sell more food and drink, and we're going in the other direction here. And we're doing that because my client wanted to demonstrate a commitment. He wanted to be a good neighbor and a good member of the business community as he transitions his business to less nightlife focus and less intense use in the late night, early morning hours. To me, that begs the question, why are we here? And honestly, I don't know. And I say that having read the WNA's protest letter, met with them for a walkthrough at the premises, participated in a mediation, read their comments to the investigator, and reviewed their PIF and supporting exhibits. As we sit here today, I don't know what their problem is. Other than the fact that this establishment exists, what we're proposing here is the type of thing that the WNA has sworn up and down the block that they want. They want more restaurant use and less nightclub-like use, and that is what we are delivering here. Why that is an issue in this case, I don't know, but I'm looking forward to their explanation today. I don't expect it will impact the board's decision-making. And what our ask is at the end of this is it seems to be we're going to be granted based on the chairman's comments as we open the hearing, but that it would be granted with only the safeguards in place that the elected officials charged with oversight of alcohol operations in this particular area have seen fit to impose as appropriate safeguards. Thank you.
I just need to get some clarification, Mr. Bianco.
Mhm.
So what are the hours? Because this is about the substantial change. So what are the agreed upon, what hours are we asking for the summer garden? So you're saying it's 24 seats.
Correct.
Right.
24 seats, and we're only asking for hours from hours until midnight for the summer garden. But
hold on. So you said hours, so Monday through Sunday?
Correct. Noon to midnight.
From noon.
Let me just confirm that.
From
application. Hours of operation for the summer garden, 9 a.m. to 12 a.m., 7 days a week.
9 a.m. to 12 a.m., 7 days a week.
Correct.
So what about entertainment?
So there's no entertainment on the summer garden.
So you're asking for 24 seats, operation from 9 a.m. to 12 a.m., 7 days a week, no entertainment. And what about alcohol sales and service? Is it the same or is it different?
Correct. Alcohol sales and service are the same.
And operation. So it's alcohol sales and service and operation on the summer garden is from 7 days a week from 9 a.m. to 12 a.m.
Correct.
Okay, so that's what's being requested.
That's what's being requested. Correct. That's what was agreed to with the ANC. So that is in the settlement agreement.
All right. So let me ask Mr. Chauvin. So you're saying that the 24 seats, 9 a.m. to 12 a.m., 7 days a week with no entertainment. So you're saying that's not agreeable to the WANA?
Well, I'm sort of being pigeonholed here. I don't want to sound that I'm against a restaurant. We welcome restaurants as long as they're de facto restaurants.
This hearing is about the operation of the asking for a substantial change. So we're not talking about what else is going on in the rest of the restaurant. The purpose of this protest is for the substantial change to add the summer garden. And the summer garden, what's been stated, it's 24 seats, and the hours of operation are from 9 a.m. to 12 a.m. 7 days a week with no entertainment. That's what I'm being told that's been asked. And so I'm just saying to you, so you're saying this is not acceptable to the WANA. Is that what you're saying?
That needs to be nuanced. That's correct. That's not acceptable. We're just asking for some nuance here. May I explain?
Yeah, what are the nuances that you're asking for, sir?
Well, just a half a block away, we have All Souls that's been operating at 725 T Street, and they're
This is
sitting
not,
down.
Mr. Chilton, this has nothing to do with All
All right.
Souls. This,
Right.
we're only talking about this establishment. Then, so you're telling me, what's wrong with the proposed hours? Why is it that you believe that it's not appropriate?
Well, the proposed hours would be fine if there were further stipulations.
Regarding the operation of the summer garden?
Yes.
And so what are the stipulations for the summer garden, sir?
That the occupancy match the seating at 24 for that location, and that they be seated during the operation, and that the sound amplification, if any, because we could not get this earlier, be at a conversational level.
There's no entertainment, sir, there's no entertainment on the Summer Garden.
Right,
So-
but you can still broadcast amplified sound. And so we'd like to negotiate how that's broadcast and at what level.
The reason I'm asking, because I'm not sure why we're having that. So if, and I'm not trying to negotiate anything, I'm just trying to move this along. So if we can have an agreement without going to a full protest hearing. So I think what's being asked, do you want me to take a brief recess so you and council can discuss what is it that you can agree to? Because I mean, what council stated to me was that he's not sure what it is that you're asking for, and so would it work if you two could take we could take about 10 minutes for you to have a conversation, for us to have an agreement, and we can have a board order on this agreement, because it's not apparent to me that the parties are far apart. Hold on, Mr. Bianco.
I'm glad to have a conversation. There's a full complement of sound mitigation provisions in the agreement we already have with the ANC. What we had offered before that's still on the table is they're welcome to sign on to it.
All right, hold on, Mr. Chauvin, have you guys seen the settlement agreement?
Of course I have. Yes, we have.
And so you know that the settlement agreement is binding on the licensee. So you're saying that you want more, that there's more that you're asking for that's not in the settlement agreement.
That is correct. Slight modifications, yes. And I'm happy to speak with Mr. Bianco, except I didn't find him to be interested in any slight modifications outside of what the ANC has already designed in their already ABCA confirmed settlement agreement. But I'm happy to have a quick discussion if we can prevent an entire hearing here.
Mr. Bianco, are you open to that, sir?
Just to simplify, we're not willing to further negotiate what we've already negotiated. They're welcome to sign on to the ANC agreement as an additional party. We're happy to have them, but we're not negotiating this piecemeal.
All right. Well, okay. Let's have the hearing then. Let's move forward with the hearing. So, all right, Mr. Chauvin, do you wish to make an opening statement, sir, or you can defer until you present your case?
Since I am a novice, my first time presenting before ABCA in a more performative and prepared way. The first time I didn't do as well as I will today. I would like to make a statement. Good afternoon, members of the board. My name is Frank Chauvin, designated representative for the Westminster Neighborhood Association for this protest. We appear today to address adverse impacts on peace, order, and quiet from the proposed summer garden at 1915 9th Street Northwest, sliced and brewed. And want to demonstrate how approval in its current form would worsen the overconcentration recognized by the North Shaw moratorium zone. We'd like to first and foremost say that we have recently been introduced to Martha, the matron of Sliced and Brewed, who started Habisha a few doors down. We love Habisha. They no longer own that. They've recently sold a bar right next door, Right Spot, right next door to their current operation. They've transferred a license or something to that effect.
Mr. Chauvin, I'm sorry, I don't want to cut to you. This is about a substantial.
Yep.
This is about a summer garden on this establishment, sir.
Sure.
We don't need to be talking about they sold other establishment. This is about a substantial change, a summer garden. This is all this is about, sir. Okay.
Sure. We're asking, due to the proximity of 150 residences, 21 feet across the alley, Those are mixed-use commercial zone residences, but also 18 RF1 residences about 40 feet away, that we have a few more fine-tuning of the operations on the summer garden, including mitigated amplified sound, and at conversational level because of the adjacent residences. And we would like people to be seated as a requirement, just like other good neighbors do in the neighborhood. And so we appreciate Martha and her decades of work. And I work closely with Mr. Abebe on this call, the operator. And so, know his good works in the neighborhood. And we just like to have some fine tuning so we can work in the moratorium and all be happy and work together and live together.
I mean, what I'm hearing, so you're asking for people to be seated. I mean, they're asking for 24 seats. So what do you mean by people to be seated? I'm trying to see where you're going while we're having this hearing.
Sure. There's a difference between seats and seated people. You can have all the seats you want and people can stand up and scream all night.
You'd like what? You're like all 24 people to be seated?
To be seated.
That no one can stand on the summer garden.
That's correct. We have it down the street, as I will show in the evidence.
But what do you mean by? Oh, okay. All right, that's fine. All right, anything else you want to say, sir?
Thank you for this opportunity and to help us be good neighbors with good commercial neighbors. Thank you.
All right, fine. All right, the board will call its first witness, Mr. Kendall Williams. Mr. Williams, can you spell and state your name for the record?
Kendall Williams.
Can you spell your name, please, sir, for the record?
Sorry. KINDELLWILLIAMS.
Good afternoon, sir. Where are you currently employed, sir?
At the Alcohol, Beverage, and Cannabis Administration.
How long have you been employed at the administration, sir?
13 months.
And what are your duties and responsibility?
To conduct inspections and investigations of ABC licensed establishments within the District of Columbia.
Are you familiar with Slice and Brewed restaurant, sir?
Yes.
And how you became familiar with this establishment?
I conducted a protest investigation of the substantial change application of Zeman M LLC, trading at Slice and Brew Restaurant, which is located at 1915 9th Street Northwest.
Did you draft a case report regarding this case, sir?
Yes.
Do you have access to your case report so you can share the report with us online?
Yes.
Mr. Oriana, can you please allow Mr. Williams to share his report?
Access has been granted.
Thank you, sir. Can you identify the document on the screen, sir?
This is my protest report for Slice and Brew Substantial Change.
And who are the current protestants for this case, sir?
The protestant is Westminster Neighborhood Association, represented by Mr. Frank Chauvin.
Did you were you able to speak to the protestant?
Yes, and I had him provide me a written statement of his protest.
All right. Let me ask you a question, sir. Regarding how many licensed establishments are located within 1,200 feet of this establishment?
Approximately 70.
And so approximately how many of these establishments have a summer garden?
27.
And what establishment? What's the closest establishment to license off the? I think you have a list of 70. What establishments are within, say, close proximity in the sense that either maybe close? What establishments are closest to this establishment, and share with me on the distance, if you're able to do that.
So across the street from, next to and across the street, it is VIP Lounge, Posh Lounge,
Hold on,
Stills.
hold on a minute, please. So you're saying, you said VIP lounge?
Yes, VIP
Uh-huh.
lounge,
Uh-huh.
posh lounge,
Mm-hmm.
sound bar,
Mm-hmm.
mirror lounge,
Mm-hmm.
SOS,
Sauce?
so SOST,
Okay.
Right Spot Lounge,
Mm-hmm.
DC9,
Mm-hmm.
LA Liquors,
Mm-hmm.
um,
And I think to make it a little bit easier, for the establishments that are within close proximity, which one of these establishments have summer gardens?
DC9 has a summer garden, but theirs is a rooftop summer garden.
Any other establishment with a summer garden?
No. I believe SOS is in the application for one, but I don't believe it has been granted yet.
Okay. So just briefly, tell me, describe the neighborhood where this establishment is located.
So the establishment is located on the 1900 block between Florida Avenue Northwest and T Street Northwest. The establishment is in a heavily populated area, an area that's heavily populated on the evenings opposed to the daytime, and even more heavily populated on Friday and Saturday nights.
Okay. I think we've already established the hours of operation. It says that the hours of operations from 9 a.m. to 12 a.m. Let's see. So I guess it'll be answered, and I think Mr. Counselor recommend. Were you able to? What's the investigative history of this establishment? Or relevant investigative history of this establishment?
As far as the history so far has just been interfere with an investigation and a change trade name without approval.
Okay. Did did you have an opportunity to observe this establishment?
Yes.
I'm sorry, go ahead. Did you do that or other investigators?
It was myself and other investigators.
All right. So tell me, how many times was this establishment observed?
It was observed a total of 10 times between October 6th and October 21st.
And were there any ABCA violations observed?
No.
What about record search regarding the Office of Unified Communications? Were you able to find any information regarding from that office?
So I tried to retrieve it, but for some reason I was unable to open the link that was sent to me, and I spoke with IT about it, and they weren't as well.
So you're not sure if there are communications from that office? No, you say you were unable to open the link, so you're unsure what this information said. Is that correct? Mr. Williams, are you there? Mr. Williams?
Yes.
You're gone for the moment, sir. So I don't know. So the question I'm asking you, are you unable to tell us whether or not there was information in those communications that would be relevant for this hearing?
Correct. I'm unable to tell.
Okay. What's the zoning for this for where the establishment is located?
It is a Arts 2 zone intended to permit medium density, compact mixed-use development with an emphasis on residential development.
All right. Let's see. Any questions by any board members?
Mr. Chair.
Go ahead, Mr. Meadows.
Yes, Investigator Williams, could you explain, talk us through your exhibits starting at number 8?
Number 8. Okay, so this is
I'm sorry, number 6, please. Thank you.
so this is the front door, the front of the establishment. The entrance is on that left side.
Mhm.
The next exhibit 7, is the first floor where they order their food from. No alcohol is served down here.
Okay.
The second exhibit 8 is their second floor bar. That is where patrons can go to order alcohol.
Okay, and that's a full service bar that you witnessed there?
Yes.
Okay, thank you.
Exhibit 9 is their summer garden.
And to access the garden, they're coming, can you go back to number 8? Where do they head outdoors?
So it will be on your left side of the picture.
In the front or in the back?
In the back.
Okay. All right, number 9.
Number 9 is their summer garden.
And so that's where they enter into the.
Yes, this door right here.
I'm just trying to establish like I was there. If you. Yeah.
Got you. Yes, so you will enter at this far left door.
Got you. And on the right, that is a cement wall.
So the right side of that left door, that's where the 2 bathrooms would be for the summer garden. The 2 bathrooms that are going to be on the summer garden.
And then I see a stairwell. Does that go outside? Where does that stairwell go?
That staircase goes downstairs to their storage area.
Okay. And was that wall recently built or was that existing?
This wall on the right, the gray wall?
Yes.
I don't know. It was there already.
All right. And number 10.
So exhibit 10 are the bathrooms.
Okay.
That will be created. Exhibit 11 is the staircase that will head down to the storage area.
Mm-hmm.
Exhibit 12 would be the storage area.
Okay.
Exhibit 13 is where the apartments are across from the summer garden area and the restaurant.
Thank you. Thank you for pointing that out. It helps me get a visual. Thank you.
No problem.
Thank you, Mr. Chairman.
Thank you. Any other questions by any of the board members? Okay. Mr. Bianca, any questions? You can close your screen, sir.
Yes, just a few for clarification purposes. So there was some testimony about other proximate establishments that have a summer garden. Do you recall that?
Yes.
And I'll just jump right to it. One of those establishments is at number 8 on your list, the Groove Lounge at 1905 9th Street. Are you familiar with that?
Yes, but I believe they are closed. They're permanently closed now.
Okay. And you had some testimony about the investigative history of the establishment, and there are 2 items on the investigative history. The first, as you mentioned, sorry, I'm just scrolling back to it. Was a 2021 fact-finding hearing, and there was no further action taken on that following the fact-finding hearing, correct? Page 10 of your report, item number 1.
Correct.
Okay. And then the second item on there was from September of 2021, and that was a secondary tier violation warning, correct?
Correct.
Okay, great. And one of the exhibits to your investigative report was the agreement with the ANC. Have you had the opportunity to review that?
Yes.
And based on your review of that and explanation of the intended operations, do you see any potential enforcement red flags that you think would be problematic?
I would say no.
And I'll save that for my client. No further questions. Thank you.
Any questions, Mr. Chauvin?
Yes, thank you. I would like to clarify and ask us a few questions here. Investigator, could you please show Exhibit 13 and I think a few subsequent exhibits in your report that show pictures of the rear side, east side of the alley with all of the 150 resident units right across from this operation? And while you're
Are you there, Mr. Williams? You're not. It says to start and share your content, but nothing's been shared. What's going on?
I'm gonna go check up on him.
Yes, thank you.
Go ahead, sir.
There's 120 condominium, or excuse me, apartment units right behind here. You'll see the metal facade with some windows.
Mr. Chauvin, I mean, he doesn't know there's 120. So just ask him if there's are there residents living? Because I'm not sure where you're getting this that there's 120, because I don't recall seeing anything in the report that's that specific, sir.
Okay. Can you show a few more subsequent email, or excuse me, pictures that reflect some additional exposures on what's behind here, investigator? There's a few more coming up. I think it's
Mr. Chauvin. Okay. You need to direct him where you want him. He doesn't know what exhibits he wants to sir.
Sure. I'm asking for some subsequent pictures past this
Hold
one.
on, Mr. Chauvin. You're asking the question, sir. You need to specifically ask him to go to the exhibit that you want him to go to and testify from that exhibit, sir. You're saying there's subsequent. I don't know where he's going, and so in order to have a clear record, you need to you know the question you're asking, sir. So you need to identify what exhibit you want him to go to and explain it, sir.
Yeah, I don't have the exhibit number, but there's another picture in exhibits which reflect.
Mr. Chauvin, all the exhibits have the numbers on it. So do you not have a copy of the case report, sir?
I do, but I don't have it printed out. I only have it online. So
I'm not going to have him go through a whole bunch of exhibits. So you need to tell him where to go, sir. You need to identify what exhibit you want him to go to and testify to, sir.
All right, there's 10 pictures here. Can he flip through the 10 pictures? They're all right next to each other.
Go ahead. Fine. Go ahead. What pictures? Starting with exhibit what, sir? What's the first exhibit number that he's looking at?
14, if you go to exhibit 14, please. I'm sorry, if you go to exhibit 12. And exhibit 11. And exhibit 10. And exhibit 9. Oh, I'm sorry. They were the exhibits by Mr. Bianco. I apologize for this a little blip here. My error. I apologize. Can I ask, Mr. Investigator, you noted that 16 times you reviewed the property. You or your colleagues visited the property. Is that correct?
No, 10 times.
10 times. And can you give me those dates that were, again, that the inspectors and investigator or visited the property and the times associated with that?
October 6, 2025, 1:15 a.m. to 3 a.m.
And so 1:15 a.m. to 3 a.m. So all 10 visits were in that time frame.
In the evenings, yes, there was one earlier in the day. Well, no, 2 early in the day.
And the reason I'm asking is because I would like you to inform the board whether you saw operations in any of those visits of this establishment.
Yes, they were operating.
Okay, and what were those what did that operation look like? What was going on?
The place would be open. If there's no patrons, there's no patrons, but the restaurant is open.
All right, and there was no patrons during that time, and that's all those visits. It was open.
Yes.
And you're sure about that?
Mr. Chauvin, the investigator stated that they were open. I mean, wasn't that his sure, and it's irrelevant. He said they were open, sir.
All right, thank you. And lastly, you made a statement about a Groove Lounge, and that was pointed out by Mr. Bianco as being the only summer garden on this alley here. Is that correct?
I stated that Groove Lounge is closed.
Yes. So there are no. So from the best of your knowledge, there are no other summer gardens on this alley. Is that correct? Because this one is inoperative.
Yes, there's no summer garden operating on this side. Yes.
Okay. Thank you. Let's see. Can you also answered a question regarding enforcement? You responded to Mr. Bianco's question as to whether there's any red flags that present themselves. Is that correct? You said no red flags?
Correct.
And what basis do you say there are no red flags? What are your characteristics or qualitative? What's your description of no red flags, or what would be a red flag to you, and what is not a red flag?
As far as their settlement agreement?
I think Mr. Bianco asked regarding their settlement agreement and their pictures in your investigation.
No, he just asked as far as the settlement agreement that he has with the ANC.
Okay.
So as far as his question, as far as the settlement agreement, no, everything looks fine in my opinion. And he already expressed to what you were asking for, no live entertainment on the summer garden, no speakers, and a small amount of occupancy.
So no speakers are not part of the settlement agreement, Mr. Investigator. So that's one of my contentions I'm drawing here. There is nothing that addresses speakers here.
It says amplified speakers used in interior must be on stands raised in
Yeah,
my
it doesn't
business
address, it
operations.
doesn't address the exterior summer garden. We're talking about a summer garden here. There is nothing
Correct.
that addresses speakers on the summer garden.
Correct. As far as the settlement agreement, yes.
Yes, thank you. And then lastly, what would a red flag to me is if there is noise, if there are speakers, how is that adjudicated? Are you involved in adjudication and investigation of complaints of noise from summer gardens?
Yes.
All right. So you can confirm or say I'm incorrect, but I understand that there's often only 5 inspectors on in the entire city at one time at night, and that sometimes it takes 3 inspectors to confirm whether a violation of the noise code exists. Is that correct?
That's
Mr.
possible.
Chauvin, all right, go ahead.
Well, I'm trying to display how difficult it is to have a affirmation by a finding by ABCA that a noise problem exists. So so there's 3 of 5 inspectors in the entire district for 2,300 licensees.
Mr. Chair,
What
I was
is
trying to
the
let this.
objection?
Yeah, I was trying to let this play out, but I have objections as to the testimonial nature of the questioning, as to the relevance of the questioning. It sounds like Mr. Chauvin's raising a legislative issue and not one that's appropriate for consideration by the board in this hearing.
Sustained. Let's move on, Mr. Chauvin.
Well, I just am trying to confirm that's difficult.
Mr. Chauvin, let's move on from this area question, sir. He raised an objection. I sustained the objection. Means that move on to a different area, sir.
Well, I'm trying to establish whether there's red flags. I will move on. I will move on. Thank you. I think that is, I think that's it for me for now. Investigative report. So just to confirm for the record, the investigative report that you noted has to do with interference with the police or ABCA investigation. Am I correct?
I'm gonna object.
What do you
to
object? What do you object into?
Questions and testimony regarding cases that no further action was taken on.
Well, I don't know what it's part of the investigative.
Very well.
It's part of the history, so I don't know what issue has been raised, but the document speaks for itself. It states what the investigative history is for the establishment. You in your opening, you talked about the investigative history. I did ask the investigator about the history. The document speaks for itself. Do you have another question you want to ask, Mr. Chauvin?
Yes. Can we iterate for the record what the investigative history is? Am I correct in recalling as the investigator?
Mr. Chauvin, we can only you see we can only speak to the record for what it says. So you can inquire whatever the document states. That's what it is, sir. So you can't ask him what it is. It's what it is.
And I can't iterate what it says.
And what does it say, sir?
Well, I think it impeded, there was an interference with the police and ABCA investigation. And I just want to confirm that's what I have taken from the record.
Hold on. Let me go to the investigative history, since we all talked about the investigative history. The investigative history, it's case number 21-251-00033, interfered with an investigation. It says that the board took this matter under advisement, so we had a fact finding here, and this is from 22, and it doesn't state what the final recommendation is, sir. So I'm not quite sure where you want to go with that.
All right.
And there's another case 21-CIT00698. It said a warning was issued, so there's nowhere to go with case number 21-251-0033 outside of what the document states.
All right. Well, thank you. I appreciate your time, Mr. Investigator.
Any other questions, sir?
That's it.
Thank you. Any follow-up questions by the investigator, by any board members? Mr. Williams, thank you very much for your testimony, sir. Have a great day.
Thank you. Have a good day.
All right. Mr. Bianco, do you wish to call a witness, sir? And how many witnesses do you have, sir? Remember, this is a limited.
Just one. I'll be quick.
I'm not asking to be quick. I'm just asking just for as time is. All right. So who's the witness, sir?
Thomas Abebe.
Thomas Abebe. Mr. Abebe, can you raise raise your right hand, sir? I can't see your hand, sir.
Yes.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Are you a witness, sir?
Thank you very much. Thomas, could you please state your name and spell your last name for the record?
My name is Thomas, Thomas, last name Abebe, Abebe.
And what is your relationship to the business M&M LLC trading as Sliced and Brewed?
The licenses are my parents, Tamru Memphis and Martha Memphis.
Okay. And what's your role with the business?
I'm helping them as a management, and I have been helping them since 1999.
Okay. And presently, how much are they involved in the day-to-day operations?
They, my parents.
Yes.
So they are there, but barely, because they are retiring right now. So they come and visit the restaurant, but most of the operation is me and my siblings handled.
Okay. And fair to say that you run the day-to-day operations of the establishment?
That is correct. Yes.
Okay. And when did your parents first start operating businesses in the neighborhood?
They came in 1991.
Okay. And how about at this particular location at 1915 9th Street?
1915, we bought it in 1997, and ever since we have been operating in this building, on and off, as a carryout and other businesses. And yes.
And when did you start working there?
I start working them 1999 as a parking attendant, because they used to own a parking right next door. It's gone now because of the building, but I start there, and I used to help them at the grocery store, and constructing all this buildings and things like that. Yes.
Okay. And could you describe the business operations at 1915 9th Street?
So currently the business operation is it was a Slice and Brews as a pizza place, but now we are changing from a pizza place to a Peruvian chicken setup with the outdoor seating, and we are pretty much the business operation is in the second floor of seating, but the first floor is a carryout setup. People can get their food and leaves, but the second floor is a seating and a bar area.
Okay. And is there any seating at all on the first floor?
No.
You do any alcohol service on the first floor?
No.
Okay. And the second floor, and the investigator showed us some photos. I'm not going to put them back up on the screen. You saw them. It features a bar area. How many stools are there?
About 8
And
stools and two high tables.
Okay. And is there any bench seating there as well?
Yes, there is 2 bench seating.
Mm-hmm. And presently, your hours of operation are until 5 a.m., correct?
That is correct, yes.
Do you ever have live entertainment inside at the property?
Only recorded music, but no live entertainment.
Do you have a dance floor?
No.
Do you have room for a dance floor?
No.
Do you ever have a DJ?
No.
Do you ever use promoters?
No.
How many speakers do you have inside of the establishment?
There are two speakers that's hanging over the ceiling, extended by a chain and a spring, so that it won't create a vibration.
Mhm.
So we built it the way that doesn't bother uh, outside the establishment, even in the storage.
Okay. And when you built the second floor, did you do anything specifically to keep your neighbors in mind?
That is correct. Yes, because we consider the neighbor. So the building is set up, on the right side there is a bar, and on the left side there is a building that's a residence building. So we build the bar, as you see on the picture. We build the bar that is almost more than 8 feet away from the residence wall. We build against on the south side, so that we can distance the noise level from the next door.
Okay. And do you recall the testimony from the investigator where board member Meadows was asking about the concrete wall on the right-hand side of the picture looking at the rear of the building? Do you recall that testimony?
That's correct. Yes.
And whose business is that on the right-hand side of your building?
It's a family business. The concrete wall is the right spot.
The right spot. So that's also a building owned by your family.
Yes, it's owned by ours.
Okay. And do you presently have any speakers on the exterior of the property?
No.
And talk about your alcohol sales over the last 5 years for Sliced and Brewed. What was your weekly alcohol sales like?
So in alcohol sale, we haven't sold much because the way we set up, we don't have the deck, and the inside is very limited seats. So we never exceed more than 500. Like a couple of times we exceeded a $500 sale, because of the way it's set up, and the pizza is a carry out rather than that somebody sits and enjoy their meal as a a meal food.
And are you presently open at Sliced and Brewed full time?
Yes. No, not full time, because there's so many conditions, and we are not fully operating, and we are waiting for this summer garden that we are working on, so that we can provide. Our plan is to provide brunch and happy hour food and drinks offering.
Okay. How many days per week are you presently open?
Presently, 3 days a week, Friday, Saturday, Sunday.
Okay. And as part of your application, you came to an agreement with the ANC, correct?
That's correct, yes.
Okay. And did that agreement with the ANC address any noise concerns?
That is correct, yes. So when this application being on and we place card, we reach out to the ANC and the WNA, and we so from ANC, Mr. Francois, and I forgot his name, but the chairman, they showed up to the establishment, and we discussed about the noise concern around the area, and then they looked at the building at the back, which is soundproof windows and walls, and they offered us a compensation, how we can work together. And then based on what they suggest, they are elected officials, so we agree their settlement agreement, and we sign it off and then present it to the board.
Okay. And in the ANC agreement, there is a paragraph entitled noise. Is that correct?
That is correct, yes.
Okay. And there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 items in that paragraph on noise. And I'm not going to read through all of them because the agreement itself is in evidence, but there's a couple that I want to talk about. I want to ask a few questions about, okay? So item J says no amplified sound in the summer garden after 10 p.m. on weekdays. Do you recall that?
Yes.
Where does that come from?
I'm sorry, can you repeat that? Like, can
Is
you
that
elaborate?
is that something that the ANC asked for?
Yes, they did ask for, and they explain, and it's understandable that amplified music, and so so that it won't bother neighbors. So we understand that part. We already understand it before they even ask for it. So
Okay.
yes.
And you're not asking to have any live entertainment on the summer garden, are you?
No.
You can bear with me for a moment. As part of the agreement with the ANC, did you agree to reduce your interior operating hours?
That is correct. We agree to reduce from our operation hours currently is until 5 a.m. But we are not interested to stay that late night. Instead, we are interested, just like the neighbors, looking forward. We are interested to earlier hours to operate the so that we can. Be operation with the neighbors. Yes.
Okay. Did you attend a meeting of the WNA to discuss your application?
Yes, I did. I did, and my siblings and my wife attended that meeting.
And were you surprised when you got a protest from the WNA?
Yes, very surprised because it was Sunday night. We present our conditions and our plans to the WNA chairman, and everybody was supportive uh, on that meeting, and because what they said was that's what they are looking for. Someone in that area, they want to move uh, towards the early hours rather than the late hours. So they really appreciate that we are taking steps to forfeit our ability to operate until 5 a.m. rather and to move it to early hours. So they were very supportive on that matter, and they were appreciating us.
Do you recall anyone in that meeting voicing opposition to what you were proposing?
No, I haven't. I don't recall any opposition, and there was a concern that they asked, but other than that, I don't recall that.
Okay. And were you there when they voted?
No. So their vote is not like ANC that they vote in front of you. They vote after unpaid members leaves.
Okay. And there's been some testimony about the residential building that is across the alley behind your establishment. Do you recall that?
Yes.
Okay. And you know the name of that building?
Yes, the Shah is. I'm very familiar because we were there when it's built.
Okay. And do they have any, are you aware that the Shea has any exterior space on the building?
Yes, they do have a patio, like a terrace with with a swimming pool right facing us.
Okay. And are you familiar with how that outdoor space at the Shea is used?
Yes, I'm familiar because I know people who lives in there. They're neighbors, and we get along with them. So yes, I know.
Okay. And could you describe for the board how the residents at the Shea use that outside area?
So yes, the Shea, they have a swimming pool with a grill and a room for partying. So they, I don't know how it works, but usually in a weekend and a nice day, they do have a party on that pool area and the decking area. They do host a party, and even the weekdays they sometimes they do have parties as well.
Okay. And do those, how late do those parties go?
As late as they I believe as late as they want, because I don't monitor them as much, but sometimes it goes late night.
Okay. And I was hoping to get through the presentation without having to introduce any exhibits, but there is one that I want to show. So if I could have permission to share my screen.
Mr. Oriana, can you please allow Mr. Bianco to share his screen?
Access granted.
So I am showing you a document that we will mark as applicant's exhibit 1. It should be up on your screen. It is a photograph. Do you recognize that?
Yes.
And what is that?
That's the swimming pool and party area of the Shea.
Okay, and let's walk through this for a moment. Where is, first of all, does this truly and accurately depict the conditions in the alley behind your establishment as they exist today?
Yes.
Okay, and in this photograph, can you tell me where your establishment is located?
Right here on the right, right by the trash can, where the yes, where the trash can. That's right there.
So if the record can reflect, there is a green and black dumpster on the left-hand side of the exhibit. Is that what you're referring to?
Yes.
And that's where your establishment is located, behind that?
That is correct, yes.
Okay. And you have been referring to a deck and pool area at the Shea. And where is that in this picture? If you could use one of the cars or other landmarks
So
in here.
right above the white car, and there's a the concrete that shows.
Okay.
Right above it, right there. That's the area. All that area is the Shea swimming pool / party grill and area.
Okay. At this point, Mr. Chair, we would move admission of applicant's exhibit number 1.
Mr. Chauvin, any objection?
Oh.
Without objection, exhibit number 1 is moved into evidence.
Quick question though, is it the whole exhibit or is it just that picture?
Exhibit 1, sir, whatever, we're moving exhibit 1 in the evidence, sir.
Just that picture.
Thank you.
It's just that picture.
Go ahead, Mr. Bianco.
Thank you very much. And do you have at your, you've already built out the deck at your establishment, correct?
Yes, that's correct.
Do you have an outside bar?
No.
Are you going to have an outside bar?
No.
How are you going to handle service of the patrons on the deck outside?
So we're going to have servers who will, after patrons seated on their table, the servers will come and take their order and then bring them food and drinks by their table.
Great. I think that's all I have for you, Thomas. Thank you very much. The board may have some questions for you, and then Mr. Chauvin may as well.
Mr. Chauvin, do you have any questions, sir?
Yes, a few questions. I need to ask a procedural question. All the exhibits submitted in the PIF.
No, sir.
Right.
The exhibits that's in the PIF, they have to be moved in evidence, sir, and there's no exhibits in evidence currently.
One exhibit.
Only exhibit 1 is in evidence. So what exhibit are you talking about, sir?
There was an associated picture showing another back of the property.
What exhibit is that, sir? That's what I'm saying. What exhibit are you speaking about?
If you give me 30 seconds, please. I'm new at all of this strategy, and I appreciate your patience. Can I describe the exhibit?
You're asking them a question, sir. I don't know if you describe it. You're asking a witness a question about an exhibit. You need to be specific what exhibit you want the witness to answer a question about, sir. And it has to be germane to the question that Mr. Bianco asked. So, is this an exhibit that Mr. Bianco had the witness testify about, sir?
It was attached to one of those pictures, but I didn't know. I thought it was one single exhibit.
If it's not exhibit 1, sir, then it's beyond the scope of his direct.
All right. Mr. Abebe, Sam, if I may call you, as we've worked together over a couple years, talking about various enterprises going on your block and on your several operations, as you know. Good to see you today. Thank you for answering just a few questions for me. You have discussed being only open on Friday, Saturday, and Sunday. Is that correct?
That is correct, yes.
And can you tell me the nature of those operations? What kind of food have you sold, or have you sold food and during those days? Or was it just alcohol you were selling? And how did you sell it? Because I'm just curious about that.
So previously we had a pizza. Since we are changing, we have Peruvian chicken mainly, but in most cases we have quesadillas, chicken wings, and fries, and pastas as well. So on the first floor, where the kitchen is, there is a majority of the time we have more food. And on the second floor, since the seats are limited, there are few people coming and eating and drinking. So our operation are limited. Currently, our operation are limited to one bartender and one server and a kitchen employee.
Thank you. And could you tell me, if you stood on the back of your deck looking out over the back alley,
yes,
you see the big building we're talking about, right?
Yes.
And just to the right of the big building is 3 condominium projects that haven't been discussed today. Am I correct?
Yes, I'm very familiar with those buildings, and when it's built, I was there.
And have you spoken to any of those folks in those buildings?
Yes, they are very friendly, and we spoke so many times. I mean, not all of them, but some of them were I'm very familiar. And during the construction with the owner, I help out some other, I help out with him, and we communicate so much. Yes.
So I was wondering, have you spoken to them about your summer garden? Because I've contacted them.
Yes, they're. I mean, not all of them, as I said, but a couple of them I have very close relationship with. They they are more interested in. They are more of interested in the summer garden, how it looks out, and things like that. Things that nature we spoke. Yes.
In the so you've had conversation with them about the summer garden and they're whether they approve it and want it behind them and if they want any conditions.
No, I did not discuss. I did not discuss such things because they never raised up, and I believe the right route is to reach out to the ANC because they are the one who's whose experience with it. So I haven't discussed with them regarding, but I'm very welcome to discuss with them if if they want, but they never approach me.
Okay, thank you for that. And then lastly, so you had discussed, you came to the Westminster Neighborhood Association, answered questions. There sounded like support and they were happy you gave up your 5 a.m. or 4 a.m. operating hours. But so you don't recall any content, any discussion regarding the moratorium and how there was a group of folks that were upset that there was expansion going on in the moratorium from establishing your summer garden.
To be honest with you, the discussion mostly it's been a while since we have that discussion. But what I recall was majorly what I recall was the most members saying this is what we are looking for. Establishments is moving from late hours to early hours, but now what they are seeing is more of people requiring their license to operate in the late hours. So they are like, we can't contradict with this part because we can't look forward on both sides. That I clearly remember that.
Thank you. And then one last question. Can you tell me, did you look at the material I submitted, the exhibits that Westminster submitted that were sent to you?
Yes.
And did you notice a letter from a gentleman that's the president of the board condo behind you, asking for further stipulations in operating?
I'm gonna object on multiple grounds.
Sustain. Like
Yeah.
you can't talk about negotiation strategies that it appears that so no.
How about evidence that were submitted?
It's if you're talking about settlements, so we can't discuss this.
I'm asking about a letter submitted by a neighbor in the condo behind him in presentation.
But what letter is that? It's not in the record, sir. What letter are you talking about? Is it in the record?
Yeah, I'd like to can I bring up a record?
And it's beyond the scope of what he asked for, so
I'd also note that there was no in Mr. Chauvin's PIF exhibit list. He said he had listed that there were neighbor letters, but there were no actual neighbor letters produced. So we don't have anything from any neighbors, and other than the line item in the PIF, we have no idea what he's talking about.
Well, it's beyond the scope, and there's no letter in evidence for you to ask him about the letter. So if Mr. Chauvin, if you have a letter, then you need to show him the letter, identify the letter as in your exhibits, then you ask him about it, sir.
All right, can I please share my video or my desktop?
Yeah, you can. I mean, if you're able to share your screen, I'll allow you to, Mr. Oriana, allow him to share his screen.
Access granted. So you want to just click share and then screen?
I will in 20 seconds here as I get to my screen.
What are you sharing, sir? I'm looking at your. When you share your screen, you're actually sharing a file, not your literal screen.
Yeah. I'm sorry, I have a problem with meetings and I'm better at Zoom. If you give me a second here to get to my folder. And what are you seeing now?
Sir, if you're opening a document, you need to open the document for him to look at that you're trying for him to share, for you want him to testify to, sir.
All right, I'm gonna open my document. Can you see my document? There's
What's the document, sir?
The document submitted by, is this from James Tawney in front of you? I just want to be sure I'm serving up the right letter.
Yes.
I'm Mr. Tawney in 1910 8th Street. He is the treasurer. He is the condominium president of the Stella Polaris condominium behind you. And as longtime residents, he's saying that we live here full time, and he would like to ask that there's a balance achieved with this back area, and that measures such as limiting the use of audio equipment outdoors and dedicating outdoor space to seating rather than standing. Can you see this letter? And it was submitted to you in the exhibit packet that I submitted.
Hold on. Yeah. What is the objection? And
Yeah. So scope, authenticity, foundation, hearsay, relevance, and the fact that this was not disclosed as part of the PIF package.
Mr. Chauvin, first, this is beyond the scope. I don't know. When you ask questions, so you ask questions that were asked by counsel. There is no question that was asked by counsel about this letter. And so I'm going to sustain the objection. The witness cannot testify about the contents of this letter, sir. Okay.
All right, Mr. Chair, if I could just appoint a point of order. I don't know if I have that right, but can I ask a protocol question?
What's the protocol, sir?
My question is, how do I present this letter in the exhibit and question Mr. Bebe on this?
Well, there's several. Okay, it's beyond the scope. Mr. Counsel is stating it's not in the record because you never disclosed it. So I
did disclose it. It was submitted to ABCA Legal. ABCA Legal has a copy of it along with.
And what exhibit is this, sir?
This is Exhibit 2. I'm just asking for a protocol because, again, I'm a novice trying to represent my neighborhood in this matter.
And who was this letter sent to, sir?
It was in my PIF filing.
No. Was this a letter sent to Mr. Bebe?
Mr. Abebe has a copy of it.
No, was this sent to him, sir?
No, it was sent to me to present here.
No, sir. You can't have. No, I'm sustaining the objection. So he cannot testify regarding the contents of this letter. So you're talking about it's beyond the scope. This is not a letter that was sent to him. So I'm not quite sure. So no, sir. You cannot. You cannot use this witness to bring this document in evidence, sir. So let's move on.
All right. Thank you. That's the last of my questions.
Thank you. Close your screen, please, sir. All right. Any questions of Mr. Abebe by any board members? Mr. Jones.
Is it possible to alter the space to allow
We can hear you.
Is your microphone? Are you unmuted? Are you unmuted?
How is the volume?
Yeah, we can hear you now. I can hear you through. I mean, I can hear you because you're sitting next to me, but I can now hear you through my headset. So go ahead.
All right. Is it possible to alter the space on the rooftop to allow someone like a DJ to enter and bring his own speaker to play music and have, a happy hour that allows for people to be standing in that rooftop terrace?
I think based on the settlement agreement, I think you need to talk about the timing, because I think the settlement agreement, they cannot have amplified sound after 10 o'clock. So you should qualify it for what time period you're speaking.
But is it even possible?
Thomas, you can go ahead and answer if you're able. I would just note for the record that there's no entertainment endorsement for outside.
Yes, that's what I was going to, because we're not going to have any DJ on the summer garden.
Thank you. No further questions.
Thank you.
Any other question by any board members? All right. Mr. Bianca, any redirect?
No, sir.
Thank you. Mr. Bianca, do you have any other witnesses?
We don't. The applicant rests. We're ready to proceed to closing whenever the board is.
Mr. Chauvin needs to.
Oh, I apologize. I apologize.
Okay. All right. So, let's, it's 3:40. Let's take a 10-minute break. And then Mr. Chauvin, I'll swear you in and you can testify. Okay? So we're off the record until, I'm sorry, we're off the record until 3:50. Okay? All right. Thanks. We're back in the record. You need to come back online, Ryan. Mr. Chauvin, now are you presenting a case, sir? Are you calling a witness? You're on mute, sir. Unmute yourself.
I will call myself as a witness.
Can you raise your right hand, please, sir? Do you swear or affirm to tell the truth and nothing but the truth? I just want to let you know that you're going to testify, then Mr. Bianco will have questions of you, and then the board might ask questions of you. So you can put your hand down, sir. Go ahead.
Yes, I'd like to present the case of the Westminster Neighborhood Association on peace, order, quiet, and overconcentration is established in the North Shaw moratorium zone today.
Remember, sir, this hearing, it's about a substantial change for Summer Garden. Now, I'm not quite sure, and we have already agreed that we're going to issue the substantial change, and so basically this hearing is whether or not we're going to put any conditions on the requests that were requested. So I'm not quite sure why you're going to present evidence on overconcentration. I'm not sure, but I just want to, okay, go ahead.
Sure. Let me just respond to your question, and then I'll call an exhibit. Overconcentration by further enlarging the alcohol service, enlarging the patrons, enlarging the space is a de facto aberration or brush upon the goals of the moratorium. By bringing more people in, we're creating more crowds, we're creating more alcohol service. And when we do, and if we do, we just want to be certain that it doesn't increase the adverse impacts that were well established and fought for 2.5 years in the establishment of the North Shaw moratorium zone. With that, the Summer Garden applicant here before us, we just want to be certain that its operations are conducive to a balanced neighborhood and not increasing the adverse impacts of a overconcentration of alcohol licenses found by this board, ABCA. And with that, I'd like to pull up my first exhibit, which is just showing again an exhibit you've already seen, but I would like to show my screen if I can.
Mr. Ariana, allow Mr. Chauvin to share a screen. What exhibit are you talking about, sir?
This is exhibit number 7. This is the North Shaw moratorium zone mapped out.
All right.
And if you could see,
you're not sharing your screen, but I guess what I'm asking, sir. All right, we know what the moratorium zone is, so why we need an exhibit on the moratorium zone?
Because I wanted to show, establish.
Go ahead, sir.
The moratorium zone and the overconcentration. All right.
We'll stipulate that the property is within the moratorium zone if that moves things along.
I don't know what he's trying to say, but go ahead, Mr. Chauvin.
All right. All right, I'm just establishing that the application here in the moratorium zone is 23 licenses in this block in the middle of 1900 block of 9th Street here. There's 23 licenses next to 1,000 row homes here. And 1,000 row homes, a residential one zone, RF1 zone. And the applicant is right here in the middle of the block. And I have another application or another exhibit to bring up here. I will bring that up. The next one will be the let's see. Request.
Hang on before we move on. So if we call that last exhibit that he had up on the screen Protestants 1, I have no objection.
All right. So, but I guess well, he hasn't asked to move it into evidence, so I'm going to ask him that.
I understand. I was just trying to move things along. Sorry.
All right. So what is it? What's the next exhibit? What exhibit is this, sir?
This exhibit just confirms.
But what exhibit number is this in your exhibit, sir? You said you said what exhibit number is this one?
I am now showing exhibit 5.
And what is exhibit 5?
The inspection licensee list for the 1900 block of 9th Street East Side.
I mean, we said what inspection? I don't know what it is. What is this inspection?
Oh, this is the, I'm sorry, this is the license list highlighted. The East Side clubs.
So let me ask you, are all these, is this a part of the case report?
This is part of the case report, my PIF.
No, sir. Are these same licenses, are they in the case report that was presented by the investigator?
Yes, I'm just highlighting the ones on the east side. Yes. So this is the case report submittal. I've highlighted the licenses, yellow highlighted, showing that there's 1, 2, 3, 4, 5, 6 licenses on the, let's see, there's 8 operators on the east side sharing this alley with the applicant. And there's only one summer garden, just the Groove Lounge, which is no longer operating. So just wanted to confirm no operation of the summer gardens in this alley. And so I want to place this in the record.
All right. Okay. So I'm going to move. That's already in the record because it's already a part of the case report. And Exhibit 7, which is the North Shore moratorium zone. Mr. Counsel doesn't object to that, so that has been moved into evidence. So those 2 documents are already in evidence, sir. Okay. What else?
Yes. I would like to show the All Souls settlement agreement at 725 T Street that was established by the ANC. And I'd like to.
Why is this relevant to this case, sir?
Because it shows how operators and residences can harmoniously maintain the peace, order, and quiet and shared nature of this neighborhood. And these are the provisions by which it does that. It's they're talking about a sidewalk cafe. So it's in the front of the building facing residences, but
this is not this hearing is not about a sidewalk cafe. It is we're about a summer garden, which is a different entity.
Right.
It's on public space. This is private space.
Right. But we're talking about a space, nonetheless, an exterior space that affects the neighborhood. So we are treating exterior spaces by way of provisions in a settlement agreement that says, applicant will restrict patrons from using electronic devices as speakers to play music in this space, exterior space facing residences. They are here reflecting what Westminster neighborhood calls a good neighbor. We're coexisting. Secondly, let's see, applicant agrees to post signage notifying patrons that business is located in a residential area and requests patrons to be respectful. And then last two ones, other noise provisions. Applicant will regularly monitor sound to ensure there's no impact on nearby residences and will use decibel metering equipment to monitor noise levels. The applicant agrees to restrict all events to those run by the establishment and will not contract the establishment for any special events to be operated by an outside contractor. And just lastly, and as equally important, capacity and seating. Applicant agrees to restrict total capacity to 33 people. Tables and chairs shall be located in this area, and the area shall at all times be operated for the service of seated patrons. That shows that they're working with the nearby neighbors' residences to be coexisting good neighbors. And at no time shall tables and chairs be cleared so as to use the sidewalk cafe area as a standing cocktail area. Only seated patrons shall be served in the sidewalk cafe area. So I just wanted to convey that half a block away, what Westminster Neighborhood Association considers a good neighbor, they're working with the neighborhood to ensure peace, order, and quiet, which we would like to ensure at this location by these simple provisions. And that's all we really are asking for, these simple provisions.
So with respect to the, I'm sorry, he didn't move admission yet. I'll be quiet.
Well, I think he wants to move to the evidence. So do you have?
We do. Yes, we object to this exhibit on relevance grounds. This is a negotiated settlement agreement from 2015 with the ANC. What is already before the board is a negotiated settlement agreement on private space, as the board noted, for this particular location, as opposed to a location a couple of blocks away. So whatever happened,
Mr. Chauvin, hold on, please.
Whatever happened 10 years ago at a different location in a different situation isn't relevant to the facts specific to peace, order, and quiet at this location in an alley.
I agree with him. So therefore, I'm going to sustain the objection. I'm not going to move this document into evidence, sir. Okay.
And Mr. Chair, may I ask why this does not support our request for peace, order, and quiet?
We're talking about it's a settlement agreement as stated by council from what, 10 years ago. This is regarding a a sidewalk cafe. We're talking about a summer garden. It's not relevant to these proceedings, sir. Okay.
All right. All right, I think I have one more item. All right. This is the board order for the emergency rules in effect establishing the moratorium zone. This outlines all of the complaints the neighbors have about overconcentration of bars, overconcentration of licenses, and the adverse impacts that have gravely continue to adversely impact the neighborhood, as there is 24 operating bars, licenses that somehow are operating in the 1900 block of 9th Street, just adjacent to 1,000 residentially zoned homes. And so I am looking for the board order that says continue. I'd like to just read the provision that instructs the petitioner for the moratorium, that's the WNA, to the board further considered, let's see, I'm sorry, 1 second, and I just need 1 more second to find my paragraph. All right. Here the board notes that various governmental and non-governmental stakeholders consult and work together to address various problems identified in the petition and by supporters of the moratorium. Discussions could entail various initiatives to address quality of life issues, such as public drinking and illegal alcohol sales in the streets, promoting the use of street-facing security cameras, and the provision of free parking ride and share metro rides and transportation options, community-wide traffic and noise studies, staggering let out at establishments, among other things. Here I'd just like to identify that the Westminster Neighborhood Association, an established community association in the neighborhood for over 30 years, is just asking the board to help with some of this and establish and find an overconcentration effects of operations that might go on this back summer garden as we're reviewing for its establishment, and that we protect the adjacent 150 residences that are in a mixed use zone and the adjacent by about 40 feet of RF1 zoned 18 residences that are just 50 feet away. We're just asking the board to further help our addressing of the adverse impacts and by slightly modifying the stipulating operations on that back deck. And I would like to clarify a question that is asked and established in the settlement agreement that is between the Sliced and Brewed and the ANC. And that is that the operations will go until midnight every night. However, the acoustic amplified sound will go till 10 p.m. on weekdays. On weekends, amplified sound will go until midnight. And so I'm asking the board to help further establish some refinements to allow harmonious living in this mixed use and residential neighborhood by the work conducted here and found here in this moratorium so we can all live together. So I've done my best here to present evidence as to why we're opining for a few more stipulations on that back deck. Love to have a restaurant in the neighborhood. And if we can get it done so it remains, co-used space, residents and operators, commercial operators like Sliced and Brewed, I would appreciate that. And I'd like to enter this into evidence.
It is, I guess this is a board order dealing with the moratorium, so it's part of the board's record, so I'll move it in evidence. If you want to object, Mr.
The board can take judicial notice of its own orders. I don't have an, I don't know that it's appropriate as evidence, but I don't think it matters one way or another.
Thank you. So I'll move that in. All right, so are you done testifying, sir? You can close your screen, please.
I have one final comment on the matter of the settlement agreement established.
What settlement agreement, sir?
This is the piece of evidence offered by It's the settlement agreement that Mr. Bianco has entered into evidence.
What settlement agreement? So you're talking about the settlement agreement that they have with
The ANC.
the ANC. It's not in evidence in this case. I mean, it has not been moved in evidence.
I think it's part of the case report, Your Honor.
Oh, yes.
It's
It
not
is
part of.
It's
It's in
attached.
it's
an
in the
exhibit.
case report.
It's an exhibit to the case report, correct?
Hold on. Okay. Okay. So what about it? What about it, sir?
That the case report offers the settlement agreement enacted by the ANC and Sliced and Brewed does not address the two stipulations that the community, the larger residential community, and the adjacent neighbors would like to ensure a co-sharing of this location by reducing the amplified sound provision. Missing from the settlement agreement is a sound noise provision limiter that would reduce amplified sound to levels after 9 p.m. on the evening to colloquial or conversational levels to protect the neighborhood, and to have seating of all patrons on the summer garden seated, because it shows a level of respect and it is conducive to the respect necessary to a shared neighborhood that is found to be over-concentrated with adverse impacts from liquor licenses and their operations. That's it for me. Thank you very much.
Any questions, Mr. Bianco?
Yes, just a couple.
Go ahead, sir.
Ms. Chauvin, I have just a couple of questions for you. So in connection with the investigation done for this hearing, you provided a written statement to the ABCA investigator, correct?
That's correct.
Okay, and that's Exhibit 15 to the case report, and that's what I'm looking at and reading from right now. And in that document, it looks like you're asking for 4 things, and I'd like to go through those if that's okay. So the first thing is no live entertainment on the summer garden. You would agree that that's off the table since there is no live entertainment on the summer garden, correct?
I would agree. However, there's discrepancy in how that's interpreted by using speakers and how those speakers are used. And so there's a problem here that we don't address. Yes, so I'll say yes to you for now. Thank you.
Okay. And then you have something in here that says all summer garden patrons must be required to be seated, correct? That's another ask that you have?
That's correct.
Okay, what about patrons being seated has an impact on peace, order, and quiet?
Yes, if you go to a restaurant, you see when people are seated, they're not standing, screaming, jumping. They show a respect for the other patrons in the restaurant. And in this case, they would show respect to the neighbors by not screaming, standing, jumping, screaming to the song being played over the amplified noise that we haven't yet controlled and I would like controlled.
Okay, so it's your contention that if they're standing, they're more likely to be engaging in behaviors such as screaming and jumping? Is that the objection?
Loud noise, over exuberant, yes.
Okay, so then moving to your next ask, you then right after that say, drinks will not be served on the summer garden, but patrons must instead go inside the premises to order, right?
Yes.
So how do
Which
you
is, I think, the case.
So how do you reconcile those two things? You want people to be seated at all times, but then you also want them required to stand up, walk across the summer garden, get a drink, and then walk back to their table. How's that reconciled?
Well, it's clearly spelled out in the All Souls Agreement, and I may not have articulated it finally, but of course there's common sense allowed here that they can walk over and get a drink and come back and seat instead of come back and be standing. I think there's common sense operations that seem to work quite well in the neighborhood already.
Yeah, I had some questions prepared about the All Souls agreement, but I think that's not in evidence, so I'm just gonna move past that. I think I understand your testimony. Um, I, I don't have anything further. Thank you very much.
Any questions of Mr. Chauvin by the board members? Go ahead, Mr. Grant.
Mr. Chauvin, thank you for being here with us today. Just for me to kind of visualize the different scenarios at stake with respect to the standing stipulation that you are proposing, can you give me maybe your vision of what it would look like if the entire area was one party? Like, let's say I had a birthday party and all of you all were invited, where it's not a situation where there's parties of 3 or 4 individually convening, but the entire space, the 24, I believe it is, seats are one party. Like, would you envision, like, if my grandmother came in the room, would I not be able to go over and hug her? Like, walk me through what it would look like in your mind if there was one party capturing the entire space.
I would say that it may not be conducive to a big party. And maybe that's the intent. A big party, as you know, if it was your grandmother's and we're all celebrating and drinking and standing and screaming and hollering because we haven't seen each other, I mean, potentially that might not happen, a big party outside, but could happen inside. And it's a thoughtful question. I appreciate that. If you're not subletting an area, you're not letting other folks promote an area, and you want to reserve outside for one big party, then we're maybe talking about not having one big party, but it's for patrons that come in and order chicken. It sounds like if you're just going to be serving, I'm a little, so I think I've said everything in response. Does that answer your question?
Yeah, and I'm only
Silas?
asking because, I'm one of the folks here making the decision, and that's one thing I have to think about myself. Like, is there an additional layer? If we have to go that deep into the weeds to say, okay, no parties of, more than 4, that's a lot for me to think through, right? So that scenario just came to mind as I heard you talk. So you did answer the question, but it does remain in my mind the thought of, hey, maybe there could be 15 people that walk in together and decide to occupy the space. And I've just not heard of any stipulation that goes that deep into the weeds. So I wanted to figure out from you what your thoughts were.
Yeah, I would like to follow up with you, actually, if I could, maybe in writing to think about that. I don't know if I can do that or if I am just sworn to answering on the spot here, but I would like to consider that more.
All right. Any other questions? Basically, after this hearing, though, the record is gonna be closed. So, I mean, I'm sorry. Hold on.
Yeah,
But,
I'll try to
no,
move.
I'll just hold on 1 minute, please. But so no, we're not gonna. You have to answer the question now. So, but provided, so I'm just gonna let you know that it's not gonna be considered if you submit something after the record is closed today. Okay, just. All right, just want to, but you can generally send something to the board as an FYI to generally cover the area, but not specific to this case after this case is closed. All right.
Yes, sir.
Okay.
Thanks.
All right. Go ahead, Ms. Quinn.
Yes, I happen to live next to a bustling place where people are often standing in kind of an outdoor seated area. So I understand the need to have some reasonable controls in place, but I also understand the need to have a good relationship between the owners and the community. And I also understand that these two things can coexist, right? I'm having a difficult time following the logic that if you're standing, you are inherently also jumping and screaming. So if you could just help me get, because I see that the place is already in operation, and is there something about Are there past violations I'm not aware of that would suggest that this is the kind of business that tends to have the kind of clientele that when standing is they're also going to be that excited and disruptive to the neighborhood? It seems like a leap there, and I'm hoping that you can help me briefly understand how you got from one place to the other.
Well, thank you for the question, Board Member Quinn. Let me try to respond in part by saying just today, the Google Maps says that this business is closed. My neighbors and I have been walking by here for 3 years. It has not been in operation. There's been nobody back there. This is a new route. This is a new summer garden. So,
But the rest of the business is open. Am I right about that?
the Google Map says closed temporarily. It's been closed temporarily from my eyes. I walk by there every single day and most weekends, and from my neighbors' eyes. And my neighbors have not seen an operation. What's going on here? We don't know. Conjecture about what kind of business goes on. They sell $50 a night of drinks or food. I don't know, but we never see anybody in there. An adjacent neighbor, 2 doors over, has told me they never see anybody in there. They never see anybody operating in there. So I'm having a hard time reconciling it being an operating business. I'm sorry. So I can't say again, and this whole area is new back there, right? There's no summer garden back there. And the only other summer garden is next door, and those folks were evicted. So, and that summer garden is no longer in operation. That's the Groove, evicted.
But these owners they didn't own the Groove, right?
No, that's
Okay.
next door. That's next door. So, I know Sam. I know he's a good person. And I've met his mom electronically here. And I know that they started one of my favorite fast Ethiopian restaurants that I take out food from. I know that. They've been good operators. And I'm just wanting to ensure, just like at All Souls, people sit and they're respectful to the neighborhood. There's some psychological benefits to sitting that are conducive to mutual respect in a shared location. And that's why that settlement agreement has been operating for 15 years. And I can't, draw my standing and jumping into the psychology of what is happening at All Souls on their residentially facing a street cafe, sidewalk cafe, but it works. And they're never in trouble. They never get in trouble for having big groups. They seem to perform well. We love them. They're working with the neighborhood. So, we're not anti-business. We just want, and so I can't answer your question explicitly. Sure. I've gone around it a little, so sorry if I may have been a little overt saying standing and jumping. I'm just talking about the psychological principle you see in a restaurant when you go in. This is going to be a restaurant. They're going to serve food. That's what's been sold to us.
I can appreciate your answer, and I'll leave you with this that I hope will help in the event that the board decides to grant this request. I want you to understand that from both as a board member, but even more importantly, as a resident of the district in a bustling neighborhood, I can tell you that it is absolutely possible to have a business that doesn't have these kinds of restrictions and does have outdoor seating that is close to residents and have them live peacefully together in a model like it sounds like very similar to what you have with All Souls, but without that restriction. I just want you to know that it's possible because right now I'm not so certain that the opposition or the protestants maybe you just haven't experienced that. And because I have, I'd like to share with you that that is a possibility. Doesn't always happen, but it does happen a lot. So I hope that there's some comfort in that if that goes that way. But thank you again for testifying today.
Thank you.
Any other questions by any other board members? Hearing none, Mr. Bianco, any recross?
No, sir.
Mr. Chauvin, do you need to provide any clarification before you rest? No. When I say clarification, means that you were asked questions by the board, you were asked questions by Mr. Bianco, but you couldn't fully explain yourself. So this is just giving you an opportunity. If for example, if you had an attorney, then the attorney would, maybe something was said and it wasn't said the way you wanted it to say, so they would give you an opportunity to, say it the way you wanted to say. So I was just giving you an opportunity to provide any further explanation based on the questions that were asked of you by Mr. Bianco and by the board.
Thank you for your very kind explanation here. I deeply appreciate it. But I do not. Thank you.
All right, thank you. So you rest?
I rest.
All right, so we're going to do closing. And so what I would like you to do, Mr. Bianco, be very specific what it is that you're asking. I mean, I think that we have already agreed that the board is going to approve the substantial change. So the purpose of this hearing is whether or not we are going to whether or not we're going to attach any conditions to the approval of the substantial change. So that's what your closing should specifically address those concerns. So go ahead, sir. I cannot hear you, Mr. Bianco.
Thank you very much, Mr. Chair and members of the board. At the outset of this hearing, I said something to the effect of, I didn't know why we're here. And I think I now know why we're here. And I don't think it really has anything meaningfully to do with peace, order, and quiet. But rather, I think it has to do with Mr. Chauvin and his group's lack of comfort with some of the operators in this particular neighborhood, perhaps the number of them, perhaps specific interactions that he's had with them. But I think there's a real lack of trust there, and it's unfortunate. And what I have tried to express in this hearing is that it's not my client. My client is a good one, and they have been for a really long time. They've done things the right way, and they did things the right way here. They approached these issues that they knew they were coming preemptively. They approached the ANC. They came to an agreement not only on conditions of the operations of their outdoor facility, which is what's at issue here, but they also, being under no obligation to, revisited some of the operational issues on the inside of their establishment and considered how those might affect the neighbors. And I think that speaks a lot about my client. And it's something you don't see a heck of a lot of, which is licensees going beyond the scope of an application to accommodate their neighbors. And that's what Martha and Tam have done for 30 years. It's what they're going to continue to do in the future. I think these licensees are deserving of the trust of the community. I think they've earned it. And at the end of the day, what we're asking for here is not extraordinary. And I think what we're asking for here is a service to the community. And it's something that the WNA specifically has been asking for more of, which is more restaurant-like behavior and less club-like behavior. And here you have a situation where a licensee has voluntarily reduced things like operating hours and entertainment and noise to make this particular business function like the sit-down restaurant that WNA says that they want in this neighborhood. We're a little disappointed that it wasn't received in a more friendly way. But at the end of the day, what we think we're asking of the board is not a very big ask. We're asking of the board to put your trust not only in my client, but in the ANC. The ANC, the duly elected officials whose job it is to consider these hyper local issues and to strike a balance not between one or two condominium unit owners that live in proximity to a particular establishment, but rather the entirety of the neighborhood and the businesses that they have to coexist with. And in their discretion, they carefully negotiated specific provisions that address issues of peace, order, and quiet. And we feel that those provisions are more than adequate. And we're not asking for a board endorsement of our client. We're asking for the board to defer to the judgment of the local officials who know this situation better than any of us do, and have struck a balance here between the interests of the business and the interests of the community, and to sign off on the substantial change with only the restrictions that are found in the already board-approved settlement agreement with the ANC. Thank you very much.
Thank you, sir. Mr. Chauvin, specifically, what is it that you're asking the board to do, sir?
Yes, as stated in the PIF, we are just asking for some minor tweaks to and stipulations in the operating of this summer garden that isn't just near a few residential units. It's 21 feet from 150 condo and apartment units and 18 RF1 zoned residential units about 30 feet away. We're just asking for the scope of the moratorium, which was found as we fought for 3.5 years of overconcentration and adverse impacts, that we are therefore now, per the board order on the moratorium, trying to work to ensure the details of this 24 licensee block, alcohol licensee block of 24 that is overwhelming and difficult to coexist in. While we understand Martha's effort and Mr. Bebe's work in the neighborhood, we would be happy to have a nice restaurant that doesn't, have some fine tuning needed to operate on their back summer garden. But we do need just a little fine tuning. And we are seated here as long-term advocates fighting for a balance. And this is just the minutia we must unfortunately be involved in to ensure continuing fine balance, because we're at a breaking point and had to work so hard. 60 residents, neighbors, opining before the board in 2 hearings before the board on to establish the moratorium. And this is just a piece of it to ensure the safe regard and livability, habitability, so people can sleep and go to work in the morning if they have to get up at 5 and 6 in the morning, which many do here in Washington, and have lived in the neighborhood for 20 and 40 years, that by implementing a sit-down seating type example set by All Souls, by in reducing or inhibiting the amplified sound on the sound garden to be voice level after 9 p.m. That's not much of an ask, and that's all we ask. That's why we prepared to be here today. And we very much appreciate you considering our hard work to be here today and our hard work on the moratorium to be here, because there's 24 licenses at this block just next to our large residential neighborhood that have adversely impacted us. And we love more good neighbors. We love more All Souls neighbors. We love a great operation by Sliced and Brewed, and we are here just fighting and yearning and asking for your goodwill on understanding this. And I thank you all for your time very much today, and for especially to the chairman, who has been quite gracious and kind with my lack of legal skills and my protocol lack. And thank you very much.
Thank you for your comments, sir. Thank both parties for their presentation today. All right, so I guess let me ask a question. The record is now closed. Do the parties wish to provide proposed findings and facts and conclusion of law or just rest on the record? I mean, in this particular case, it's not necessary since the parties have already agreed that the board will grant the license. However, with whether or not the portion that we have that we're going to decide whether or not we're going to have what restrictions, if any, will we add to this granting of the stipulated license?
Applicant does not intend to file proposed findings of fact and those conclusions of law.
I am not certain whether we do, but in goodwill gesture, for now, I have to say we will also not file, but I hope I'm not giving up my rights
You're not
to protect and our interests. Thank you.
You're not giving up any rights, sir, but thank you for that. The record is now closed, so let me, yeah. So, all right, as, let me close this case. So as chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Code Section 2-575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 25 PRO 00075 Slice and Brew Restaurant, pursuant to DC Official Code Section 2-575B4A of the Open Meetings Act, and deliberating upon case number 25 PRO 00078 Sliced and Brew Restaurant for the reasons cited in DC Official Code Section 2-575B13 of the Open Meetings Act. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll now have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones. And Mr. Anderson, I agree. The motion has passed 5-0. I hereby give notice that ABC Board will recess its proceedings to hold a closed meeting pursuant to Section 2-575 of the Open Meetings Act. Thank you very much for your presentation today. The board will issue a decision within 90 days. Thank you. Have a great day. The board has now concluded its business for the day, and so let me close the record. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with Title III, Chapter 405, Office of Open Government, I move that ABC Board hold a closed meeting on October 30th for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations, and seeking legal advice from our legal counsel on the board's investigative agenda, legal agenda, and licensing agenda for October 30th, as published in the DC Register on October 24th. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. I will now take a roll call vote on the motion before us now that has been second. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones and Mr. Anderson, I agree. As the motion has passed, I hereby give notice that the ABC Board will hold this closed meeting. Pursuant to the Open Meetings Act, notice will also be posted on the ABC Board here in the room bulletin board, placed on electronic calendar and APCA's website, and published in the DC Register in as timely a manner as practical. We're now adjourned for the day, and I'm looking to my left and looking to my right, seeing my board members, so it's good to see you in person. We came in the office today, but it appears that we've had more technological issues being here in person than when we're remote. But if there were any, I apologize to the public, but it is good to see your board members to work collaboratively with you from side to side. I know people might see folks walking. Normally, when we practice remotely from home, you never see anything in the background. But today we're in person. You see folks walking in the background. But just want to let you know that. And Mr. Mr. Jones, why are you in my screen since we're not in the same location? Of course, he's right, he's sitting next to me. Anyway, but it's good to, and in all seriousness, it's good to see you all and work together. So now we are adjourned for the day, and we will be back on the record tomorrow. We'll have a hearing tomorrow at 1:30 in the afternoon, so we'll be back. All right, so have a great afternoon, And thank you for the public who participated in the hearings today and the board members. Thank you. Have a great day. Thank you.